Good morning. This is the Colorado Energy and Carbon Management Commission. It is Wednesday, December 13th, 9 a.m. We will initiate with a roll call.
Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner McGowan. Commissioner Mesner.
Here.
Commissioner Oath. Commissioner Ray. Commissioner Robbins.
Here.
Mr. Chair, you have 4 of 7 commissioners present.
Great. And that is a quorum. I do note for the record that Commissioner McGowan will be with us a bit later this morning. She's undertaking other ECMC business. So we'll start with a pretty lengthy agenda for the next day and a half or so. We've got commissioner comments first. Does any commissioner have comments for ourselves and our stakeholders? Commissioner Cross?
Thank you, Mr. Chair. And I just want to say thank you to those throughout the state that have attended our disproportionately impacted community forums that we've been holding for the last week or so. We will provide more updates on it, but we did have pretty good turnout in Greeley, in Erie, in Commerce City, and in Rifle. So I just want to say thank you to the public that reached out, and remind everyone that we do have another remote hearing on Tuesday the 19th. So I encourage more to sign up for that as well and continue to participate. And thank you again for the feedback we've received thus far.
Yeah, thanks to you and Commissioner McGowan for leading the effort on those meetings. We really appreciate it. We look forward to getting some feedback. I believe, Hearings Manager Thomas, that we were going to hear from the one member of the public who signed up. Is that right at this point before we move to Director Murphy?
That is correct. We're elevating Barbara Mills-Bria right now.
Okay.
Yeah, thank you for letting me comment this morning. I'm Barbara Mills-Bria. I'm with Be the Change Colorado. I want to thank you for letting me comment. In light of Ms. Murphy's information concerning the CLOC 1 well, which she's going to be presenting this morning, 2 questions have occurred to us. First of all, once a well has been plugged, who becomes responsible for that well? As we all know, wells need to be replugged after perhaps 10 to 20 to 30 years. Plugged wells can leak or worse, as became apparent a week or so ago. And so is the Colorado taxpayer responsible for the next decades once an operator has plugged a well, given that tens of thousands of wells have been drilled here? Then second, I'm assuming that the financial assurance effort has been completed. I believe that by law, it should have been completed at this point. In any case, will the commission be giving the citizens and taxpayers of Colorado an update soon? Thank you for your time this morning.
Thank you, Ms. Mills-Bria. We appreciate you being with us. We can unelevate Ms. Mills-Bria at this point, and I believe we're going to hear from Director Murphy.
Thank you, Chair. Thank you, Commissioners. I wanted to provide a brief update about the CLOC #1 well. I think, some folks are aware of it. We've had information posted on our website about it. And with that, I would just jump in, which is that on the evening of December 5th, 2023, ECMC was notified of a well failure in the town of Johnston by the Front Range Fire Department, the emergency responders. A Barrett Resources well, CLOC 1, was previously plugged and abandoned in the 1990s. The plug failed. ECMC had personnel on the scene on the morning of December 6th after being notified, and began work to bring in equipment to plug and abandon the well or replug and abandon the well. We coordinated closely with emergency responders, the town of Johnston, and the Colorado Department of Public Health and Environment that morning. And we did notify, and we provided information as well to the nearby neighborhood about the well and on the ECMC website. On December 6th, the Public Health Department deployed their mobile monitoring lab, which collected measurements as it drove through the streets near residences and in the vicinity of the well. The mobile lab was then parked within 50 feet of the well, where it continued to collect measurements. The mobile monitoring lab did not detect benzene, toluene, ethylbenzene, or xylene, which are collectively known as BTEX, above the lab's detection limits for the period it was deployed. I want to extend a great deal of gratitude to CDPHE as their team mobilized as quickly as they could and got on site in support of these initiatives. On December 6th, we also procured emergency funding and mobilized an in-transit workover rig to replug the well. So again, thanks to the teams that have been working on getting that emergency funding authorized and getting our rig that was otherwise going to be plugging an orphan well moved over to immediately begin work on the CLOC number 1. We had the rig on location and began route entry and plugging operations on Thursday, December 7th. So, and at that point in time, the well had been stabilized and work this week is being done to replug the well. We will continue to work to remediate the site and provide updates to the town and neighbors as necessary. We have received one complaint from the neighbor who identified the incident and have been following up in investigation. In addition, we reviewed the CLOC number well file, or sorry, CLOC number 1 well file to understand information about the plugging of this well and that plug job did not meet the commission standards. As a result of this information, we have also reviewed all of the well files for the wells that were plugged by this operator to evaluate whether there were other wells that may have a similar inadequacy in the plugging job. One of those wells is part of an emergency order that we have on before the commission requesting permission to add those wells to our orphan well list. And I think that as we continue to move through the file, we may add additional wells in the more permanent order. And of course, as we continue to learn more about this situation, we will continue to evaluate what additional steps we need to take to understand wells that have been plugged. I think as we understand this unique event, it's pretty important to also understand the context from the Colorado State University study that we commissioned, that ECMC commissioned this fall. We had asked CSU to study orphan well emissions from both plugged and unplugged wells. And the study showed, or the study did not find any emissions from wells that had been plugged that were part of its study. So I think, again, that's important context to understand that, yes, we had an inadequate plug fail in this well, and that we have information that plugged wells that have been plugged somewhere between now and 50 years ago do not have emissions. Again, we are committed to transparent, timely, and accurate information. I cannot, again, express enough gratitude to the Department of Public Health and Environment, our partners at the Department of Natural Resources, the emergency responders, and the local government as we worked through this issue in a seamless fashion. I mean, the way I've summarized it internally is that by the time I thought to ask, is something happening? As we coordinate with these different partners, it was already in the works. And so I'm just grateful for the relationships and the work ethic and the attitude of just kind of jumping in and getting things done. So in addition to the steps that we've already taken, if there are additional questions or information, we have our ECMC complaint opportunity on our website. CDPHE has its health concern contact for the CDPHE Oil and Gas Health Information Response Program. So I hope that kind of gives an overview of where we are. We hope to have the well fully plugged by the end of this week and have that rig moved back to the well that it was on its way to plug. We are requesting that this well and another one be added to our orphan well list. And I would remind folks that our orphan well program is funded collectively by funds from the IIJA, the Federal Infrastructure Act, funds collected from industry pursuant to our annual well registration fee, and from operator financial assurance that we have collected through either our historic or current financial assurance program. So with that, Chair, I would wrap up my remarks, and I'm happy to answer questions. I can't hear you, Chair.
Great. Thank you very much, Director Murphy, for the update. Listening to the response and listening to the action items of both ECMC and CDPHE, it's not something that we are excited to learn about, but it sounds like the expedient response was exactly what was called for. And I think it's an excellent opportunity to show that our agency and CDPHE are able to work together to respond proactively to an emergent situation such as the one as existed here. So thank you very much for the update. I think that update is very helpful for all of our stakeholders to listen into. Do any commissioners have comments and or questions for Director Murphy? Commissioner Ackerman.
No, I just wanted to add on, and I'm sure you have already, Director Murphy, but thanks to staff as well, a significant number of staff. Really, when I see something unfortunate like this happen, the response and the expertise that's brought to bear is considerable on all fronts, including staff, and just really appreciate your work and the work of staff.
Thank you, Commissioner. I agree. Our team has been excellent and responsive, and just I'm deeply grateful for their expertise as we've had to jump into this, as you noted, unfortunate situation.
All right, seeing no further questions, we have a consent agenda next. Does anybody have questions, or do we have a motion?
Move to approve consent.
I'll second.
Motion and a second. Further discussion? Seeing none, all those in favor of consent signify by saying aye. Aye.
Aye.
Great. Consent agenda passes. According to my agenda, we're back to Director Murphy with a geothermal update.
Great. Thank you, Chair. Sorry, I somehow thought I'd have more than 32 seconds to like regroup my thoughts, but I don't, and that's totally okay. I know that folks have been really watching our geothermal process very closely. We're really excited about this work. And given the volume of stakeholder feedback and our opportunity to really try to strike the right balance as we draft this first set of rules, we've slowed down our process a little bit to be able to really incorporate that feedback, integrate it. And as many of our stakeholders know, maybe not as well if they're just in the deep geothermal space, but there is a lot of regulatory activity across our agency and the Department of Public Health and Environment, which is fantastic and wonderful. And so we are working hard on integrating that feedback. Again, we've slowed down our process just a little bit. And given that APCD is in the middle or is initiating a rulemaking today on the ozone SIP, and that ECMC has a statutorily required rulemaking in April on cumulative impacts, which I think is a broad, meaty, and critically important topic, we're trying to figure out where to nest in the deep geothermal rulemaking. And so all of that to say, you know, we hope to have a revised set of draft rules out in the coming couple of weeks. And at that point in time, would probably have a revised, more precise timeline, but wanted to let commissioners know where we are. We're working on integrating feedback. We want to be very respectful of other commission processes and other drains on stakeholder resources as we work through this important issue for Colorado. So not maybe the most substantive update, but wanted to at least let folks know where we are before we head into the holidays. And that nobody's going to get a surprise set of rules dropped on their desk, you know, someplace between Christmas and New Year's.
Sounds good. Appreciate that. I think it's more important to get it done right in a timely fashion than to expedite through something. It's a very important process. So thanks for the update there. Any questions for the director? Commissioner Messner?
Thank you, Mr. Chair. Thank you, Director, for the update on the geothermal. You know, I wonder if I could request that some consultation happen individually with commissioners on that as well, because I understand there's different feedback that's being provided on the initial set of draft rules, but I was pretty comfortable with the initial set of draft rules, and so certainly would like to be able to share some thoughts in drafting whatever revisions may be occurring. So
thank you, Commissioner. Yep, we will get that scheduled.
Thank you, Director Murphy. Speeding along with our agenda, we now will turn to our first docket. 170500289. This involves order number 535827. This is an update from Great Western Operating Company on the Pierce URU annual update. Ms. Wozlinski.
Good morning. I've just joined the panel and I actually I'm seeing a couple of our panelists arrive. So I'll make sure everyone's on and we're happy to start sharing our screen and give our brief presentation.
Who are we looking for to make sure that we get them up?
Looks like everyone is coming in now, Chair. Let me see. Tony Williams, I believe, is the last. Oh, he's on.
Yep, I see Mr. Williams,
Fantastic.
Mr. Sims, Ms. Jost, Ms. Bulow.
Great.
If you want to have your witnesses visualize themselves, we'll have AG Mercer swear them in.
Wonderful. And Miss Bulow is only screen sharing, so I don't believe she needs to be sworn in, but I'll have Tony Williams, Tyler Sims, Doug, and I believe, and Mike Marini. Do we have Mike on? Looks like we are missing one panelist, Chair. Apologies. If you would like, we can swear everyone in here. And if there's a question that Mr. Marini needs to answer, we can swear him in at that time.
Very good.
Good morning to the panelists. I'll just go one at a time and ask you each to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Mr. Dennison.
Doug Dennison, I swear to tell the truth.
Thank you. Mr. Sims? Oh, you're on mute. We are still not hearing you, but I think we can read your lips, and I see that you said you swear to tell the truth. And Mr. Williams?
I, Tony Williams, swear to tell the truth.
Thank you.
All right, Ms. Wozlinski.
Thank you. We will start sharing our screen, and then I will get started. Perfect. We'll just get that in presentation mode. Great. And Maggie, it looks like we can see a subtitle link and future slides. And if you just want to click off of that, but I'll go ahead and get started. Well, good morning, commissioners. My name is Kelsey Wozlinski with Jost Energy Law. And with Jamie Jost, we represent PDC Energy in the Pierce Unconventional Resource Unit, or URU, before you today for an annual review. As you're all aware, on August 7th, 2023, Chevron acquired PDC. However, PDC is continuing to operate as a wholly owned subsidiary of Chevron. Next slide. I'll provide just a brief overview of the Pierce URU before Tony Williams provides an update on Chevron's evaluation of the Pierce URU development. The Pierce URU Order 535-827 requires that the URU be set for review by the Commission annually, and notably no action is required by the Commission today as part of this review. The approximate 4,800-acre Pierce URU was initially established by Great Western Operating Company on June 12, 2017. Great Western had been providing annual updates to the Commission through 2021, and PDC gave its first update in 2022 after acquiring the assets of Great Western. Next slide. So Jane Stanzik presented a great summary of URUs to the Commission in 2021. That does provide a helpful background of URUs and why they have been established, and two of these slides are shown here. URUs have been recognized as an important tool by the ECMC and are focused on downhole mineral development to protect mineral owners. The URUs that have been formed in Colorado were established primarily to protect mineral owners in the development of unconventional reservoirs and to provide flexibility to operators to develop a resource as the operator's technical understanding of the subsurface resource grew. And to this end, the Pierce URU order allows for the appropriate number of horizontal wells to effectively and efficiently drain the reservoir. A URU can be considered a hybrid between a DSU and a state unit, and the Pierce URU order provides that the URU will be governed by a unit agreement and unit operating agreement. Next slide. As more background, PDC now owns the 88.2% working interest in the URU, and 2 of the larger leasehold owners have provided letters of support for the URU development. And as I previously mentioned, the Pierce URU is governed by a unit agreement and a unit operating agreement. Next slide. This map shows the PDC leasehold within the URU in yellow, and the 2 drilled URU wells drilled from a north to south orientation from the existing Riemann pad. Next slide. This is a summary of the Pierce URU timeline. The first URU well was spud and completed by Great Western in 2019, and gas takeaway was also established in 2019. The second URU well was spud and completed by Great Western in 2021. PDC then acquired the assets of Great Western in 2022 and proceeded to file 4 new Riemann APDs for additional north to south development of the Pierce URU from the existing Riemann pad. Chevron acquired PDC in 2023, and as of November of this year, all 4 of the new Riemann APDs have been approved. I'll now pass the presentation over to Tony Williams to discuss the future development planning and geology.
Thank you, Chair and Commissioners. Thank you for the time. Let's go to the next slide. This slide shows you within the blue box where the URU exists. It also shows you the top of the Niobrara Formation and the structure complexity in the subsurface. The warmer colors are shallower, and the lighter colors, or the cooler colors, are deeper. You can see there's a structural fault that wraps through this area with about 250 feet of offset. This is noted in the literature and also seen in the seismic. The URU wells are planned around this unique feature, and the geometry is consistent with other wells in the basin and how they've developed the fields. Let's go to the next slide. On this slide, you can see the approved APDs that was spoken about before on the Riemann pad. These are test wells. They are approved in June of 23 and November of 23, and they are targeting multiple benches in the Niobrara Formation. These wells, the wells on the pad are coming off the existing Riemann pad that we have already acquired and already drilled the other 2 wells from. There are no RBUs within 2,000 feet. The RBUs order allows us to have 6 pads within the adjacent to the URUs. And this is typical with what we've done in the past. We also are looking and reevaluating this area now that it is owned by Chevron. And the URUs are currently being looked at with the 3-year time term on the Riemann pad APDs. And that is our update for this year. Appreciate your time.
Great. Thanks for the information. Questions from commissioners? Commissioner Messner?
Thank you, Mr. Chair. Thanks for the presentation. Can you provide any update on any changes in the surrounding surface land uses, or any anticipated future land uses that are being contemplated in this particular area that is affected by the URU?
Thank you, Commissioner. I'm not sure if Doug Dennison or Tyler Sims would know or have an update on the land use for the Riemann pad or other. I believe right now there's a Riemann pad and a T&M pad, and only the Riemann pad is being utilized for the URU development.
Kelsey, I can try to take that. Can you guys hear me now?
Yes.
Okay. Thank you for the question, Commissioner Messner. Right now, given the the timeline of the URU since the acquisition by PDC and now by Chevron. Excuse me, we're still in the evaluation phase of utilizing the pad that we have. So while we do have the ability through the agreements that are in place to potentially use future locations, we aren't there yet. So to the point of growing and using other surface sites, we would go through the full OGDP process should that actually happen at a future time. But right now we are not looking at what's been happening on the ground with the surrounding at this point.
So thanks for that answer, and understand that you were talking about surface uses for your operation. I didn't know if there was any contemplated surface uses that are not being contemplated by you. So is there, subdivisions being considered? Is there, other surface uses being considered around the existing pad? Understanding that the URU, does create an extended opportunity to be able to drill wells in this particular location. So I'm just looking for an update if things have changed on the ground surrounding this that can be reasonably anticipated.
Yeah, I appreciate the clarity with that. And that is not something that I have looked at, and I don't have the ability to answer that right now, but we can get that answer for you.
That'd be great. I mean, I think that's good information to know, just because we are, in these particular situations, looking at situations that can change because of the timelines associated with operations like this. So that would be helpful for me.
Other questions? All right, we appreciate the update, and we will allow the parties to move on with their day.
Thank you.
Okay, we do have a lengthy agenda, so we're going to keep plowing through it. We should elevate the parties involved with the incline operating OGDP. That is docket 2303000070. You're going to be a panelist for this docket. Go ahead and visualize yourself, and we'll get you sworn in. Mr. Willis, I see 4 witnesses and a cat. Is that about right?
Well, yes, I'm not sure about the cat, but
I'm so sorry.
It's okay. I mentioned the cat in a jovial manner. You all appreciate our pets and the warmth they bring to us as we work from home.
Thank you.
Ms. Mercer, please go ahead.
Thank you, Mr. Chair. Members of the panel, good morning. I'll just go one at a time in the order I see you on my screen and ask you to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Mr. Peterson. Oh, you're on mute, sir.
I do swear to tell the truth.
Thank you. And your name for the record?
Andy Peterson.
Thank you. Ms. Friday?
Julie Friday, and I swear to tell the truth.
Thank you. Ms. Feldman?
Ann Feldman, and I swear to tell the truth.
Thank you. Tempted to swear your cat in, but I will move on to Ms. Holliday.
Thank you.
Kelly Holiday, and I swear to tell the truth.
Thank you.
Mr. Willis, the floor is yours.
Thank you. I'm looking at the agenda today, and I note that Miss Holliday has 5 minutes. Would you like to start with her, or would you like Incline to start its presentation? And I can't hear you.
Ms. Holliday, you're here to testify on behalf of Weld County, so let's go ahead and hear from you first.
Okay, thank you, Chair Robbins. Good morning, commissioners, and thank you for the opportunity to speak today about Weld County's 1041 WOGLA process regarding the Incline Dittmer Oil and Gas Development Plan. Weld County's Oil and Gas Energy Department held a pre-application meeting for the Dittmer pad on September 28, 2022, at which several alternative sites were discussed. Attendees included Weld County staff, Incline Energy, as well as their consultant, Ascent Geomatics, ECMC staff, and the Adams County LGD. CPW and the City of Brighton were invited but did not attend. All attendees and invitees received a copy of the meeting notes. It is important to note that Adams County is not a proximate local government to the Dittmer location, but due to Weld County's process and our desire to have a wholesome conversation at the pre-application meeting, they were invited due to the drill spacing unit bordering Adams County and some alternative locations that were discussed in Adams County. The initial 1041 WOGLA application was received on March 14th, 2023, and after further discussion with Incline to clarify and enhance certain items, the final application version was submitted on April 21st, 2023. There are 12 building units as defined by Weld County's code within the 1041 WOGLA zone. And Weld sent notices of the hearing to the 25 individual property owners around the location. Throughout the Weld County application process, we did hear from 3 members of the public. We received 1 letter from a property owner and 2 phone calls, 1 application for intervention or request to participate at our hearing. The letter and intervention party were the same person. After speaking with both of the callers, they did not have any further questions or concerns and did not have any concerns with the proposal. We encourage public participation and believe this is an example of participation early in the process, asking questions and getting answers. The operator agreeing to certain BMPs, which in the end resulted in no public comments to the ECMC. One item to call out and give kudos to Incline about is the fact that this was the first 1041 WOGLA application where we felt it was worthwhile to request a visual mitigation plan as part of our permit. Incline will be utilizing a combination of a 6-foot privacy fence along with an earthen berm to create visual barriers to their location to the public. We applaud Incline for working with us on this mitigation effort. The 1041 WOGLA hearing was held on June 29th of 2023. At this meeting, the hearing officer took testimony from Weld staff, the Incline Energy, and the intervention party. After considering all the testimony, the facts presented, the hearing officer approved Incline's Dittmer pad. The final order was recorded with the Weld County Clerk and Recorder on July 5th of 2023 and was noticed in the Greeley Tribune on July 7th of 2023. 2A comments were submitted to the ECMC on October 26th, 2023, and are included in the director's recommendation. Weld County agrees with the director's recommendation and supports approval of this OGDP. And that's all I have for you today. I'd be happy to answer any questions.
Thank you, Ms. Holliday. You mentioned that this was one of the first WOGLAs that Weld County determined needed a visual mitigation plan. What was the rationale for that conclusion?
I think mainly based on location and just proximity to other development and to the public eye, where a lot of locations within Weld County are in more remote areas. This is in more of an urbanized and developed area.
Okay, thank you very much. Further questions for Ms. Holliday? Commissioner Messner.
Thank you, Ms. Holliday, for being here and providing the local government perspective. I wonder if you could elaborate a little more on the intervention party's concerns that were brought up during that hearing.
I would actually have to dig into that a little more, as I'm not the one who presented on that hearing. But I can definitely do that and get back to you in a minute.
That'd be great. Just trying to understand what the concerns were, whether they were noise or odor or lights or health concerns or what that may be.
Yeah, if I can just have a moment to look into that in a little more detail, I can absolutely get back to you.
Okay, why don't we do this? We'll let you go do that inquiry, and once you're ready to present, if you just want to visualize yourself again, then we can interrupt the proceeding and have you answer the Commissioner Messner's questions.
Okay, thank you.
Further questions at this point? All right, Mr. Willis, you're up.
Thank you, Chair. Good morning, Commissioners. My name is Rob Willis with Post and Odell Peterson Law Firm. I represent Incline Operating LLC today, a subsidiary of Incline Energy Partners LP in the the Dittmer unit, OGDP, before you in docket number 2303-00070. Incline would like to thank Ms. Holliday, her staff with Weld County, as well as CPW and CDPHE staff, along with the commission staff, and especially Director Murphy, as they've worked through this OGDP process. I'd like to pass the case over to Julie Friday with Incline for presentation. And I do believe she'll be driving the PowerPoint presentation. Thank you.
Ms.
Thank you,
Friday.
Mr. Willis. Let me just get the presentation up. Can everyone see it?
Yes.
Okay, great. Good morning, Chair Robbins and Commissioners. My name is Julie Friday, and I am the Vice President of Development at Incline. We've been working really hard on this project for 5 years and are excited to finally be at a point to present it to you all today. In the presentation, I'll cover a variety of topics, including our alternative location analysis, siting considerations, best management practices, and community outreach. Incline has been doing business in the state of Colorado since 2010 and has traditionally focused on acquiring non-op working interest and royalty interest. However, we became a bonded operator in Colorado in 2018 and developed our first well site in 2021. Next slide. The Dittmer unit OGDP proposes a new oil and gas location, the Dittmer pad, to develop 16 horizontal wells within a proposed 1,280 acre drilling and spacing unit for the Niobrara, Fort Hays, Codell, and Carlisle formations. Incline has complied with all notice requirements for the Dittmer OGDP. No formal petitions were filed and no public comments were received on the Form 2A. Incline requests that the ECMC approve the Dittmer unit OGDP, establish the proposed drilling and spacing unit for the application lands, and approve the Form 2A for the Dittmer pad. Next slide. Before going any further, I want to point out a few updates to the application since we submitted it in March. First, there were 11 RBUs within 2,000 feet of the working pad surface when we submitted our application. However, since then, the status of 3 of the RBUs has changed, and after further consultation with the ECMC, we believe that there are only 8 RBUs within 2,000 feet of the working pad surface. I will go into more detail about the RBUs in the next slide. The next major update is that we are now able to commit to having an oil pipeline takeaway in place at first production, which affects the number of tanks on location, tank volume, and air emissions. Lastly, when we submitted our application, we submitted that we would use Tier 4 engines for drilling. However, those engines are not readily available in the DJ at this time. And as we told the CDPHE during our consultation, we can no longer commit to using Tier 4 engines for drilling, but we will certainly try. At this time, we can commit to using Tier 2 engines with natural gas battery assist until Tier 4 becomes available. Next slide. As I previously mentioned, the number of RBUs within 2,000 feet of the working pad surface has changed from 11 at the time of submittal to 8. RBU 2 and RBU 3, which are located just northwest of the Dittmer pad, have been converted to an office and a storage space. So we don't believe that either structure should still be considered RBUs since they are no longer residences. The other RBU that we believe shouldn't be counted is RBU 13, which is located just southwest of the pad. The RBU doesn't have any running water and is considered uninhabitable by its owner. We consulted with the ECMC about the status of the RBU in November, and they said that if they do not have a reasonable belief that the structure could be inhabited as a residence, they have been excluding structures from the RBU count. Since the owner doesn't consider the structure livable and won't have anyone there and it will remain vacant, we don't believe it should be counted as an RBU, bringing the number of RBUs within 2,000 feet to 8. Of the 8 RBUs, there are 0 within 500 feet, 2 within 501 and 1,000 feet. 1 is tenant occupied and 1 is vacant. Between 1,001 feet and 2,000 feet, there are 6 RBUs. 5 are occupied and 1 is vacant. The closest RBU to the working pad surface is 756 feet to the west. Since we're now able to commit to an oil tankless facility, the emissions data that we submitted with our application, which is what is shown in the first table, should be updated to reflect the numbers in the second table on the slide, which shows the emissions data for the Dittmer pad when the oil tanks are removed and the oil takeaway pipeline is in place at first production. And then the last table just shows the reduction in emissions when we change to an oil tankless facility. Next slide. Those are all the application changes, so now I can dig into the OGDP application. The proposed Dittmer pad is located in the northwest quarter of Section 32, Township 1 North, Range 66 West. As previously mentioned, we plan on drilling 16 horizontal wells from the Dittmer pad, where Incline has an executed SUA with the surface owner. The land is not actively farmed. It's currently being used as a well site for a third-party operator and as the CCWCD's recharge augmentation ponds. The OGDP requires approximately 12.3 acres of total disturbance. The oil and gas location will be 10.1 acres during operations, but will be reduced to 7 acres after interim reclamation. The new access road disturbance is 2.2 acres. Incline received an approved 1041 WOGLA permit on July 5th, 2023, and our BLM APDs are pending, but we expect approval any day now. This location meets one rule 304 B2B criteria, but is outside of all other ALA benchmarks, including high priority habitat and designated outdoor activity areas. Incline has worked hard to ensure that this pad meets the criteria for Rule 604 B1, which states that all RBU owners and tenants within 2,000 feet of the working pad surface have granted informed consent. Next slide. Before Incline identified the Dittmer pad as its recommended location for the Dittmer unit OGDP, a wide range of other locations were carefully considered during an exhaustive ALA process. Next slide. In 2018, we began permitting the Iberger pad, also known as Alternative Location 18, which was the first well site chosen to develop the unit lands. We signed an SUA with the surface owner and obtained an approved WOGLA for the location. However, because the site was located within the floodway, we needed a separate site for the production equipment outside the floodway and preferably the floodplain as well. Incline considered the following 2 locations for a separate facility site. Alternative Location 19. The surface owner of the property where AL19 is located would not sign an SUA. However, they did agree to sell the property to Incline. Unfortunately, the sale did not go through because during our due diligence, we discovered that there's a mining permit and obligation on the property that would require Incline to assume the liability to complete the reclamation work, which is really outside of our scope of business. And so we didn't move forward with the sale. The second facility site we looked at was Alternative Location 20. However, we couldn't agree to contractual terms with the surface owner. And after unsuccessful negotiations, we began looking for a well site where we could operate from one location. Alternative location numbers 3, 4, 7, 8, and 10, all located on the western side of the unit, were all considered preferred sites to drill from because the low number of RBUs surrounding the locations and reduced risk to the environment and wildlife. However, a majority of the western side of the unit is owned by one farming family who will not entertain the idea of having a surface location on any of their property due to their ongoing farming operations. Alternative locations 1, 2, 5, and 6 are also owned by that same family. However, they're not preferred due to the number of RBUs and other 304 triggers. And just to give you a little background on how much contact we've had with that family, since 2018, Incline has made multiple efforts to contact the family about an SUA, including making efforts to purchase the property. In addition to its own efforts, Incline has tried getting in touch with the surface owner to discuss an SUA through a contract surface landman, local realtor, the surface owner's attorney, a midstream company, and a mining company who has worked with the surface owner in the past. All efforts were unsuccessful. And as a result, utilizing any of these locations and a few others I'll mention without an executed SUA would require providing a financial assurance surety bond under ECMC 700 series rules to access the location without the owner's permission. Next slide. Alternative location 9 was also another preferred location due to the reduced risk of human and environmental impact, but it's owned by that same farming family previously discussed. Alternative locations 11, 12, and 13, also owned by the same family, but they weren't preferred just due to the number of RBUs and 304 triggers. Alternative locations 14 and 15, they're owned by a developer who would not enter into an SUA because of their plans to develop the property into residential and commercial development. Alternative location 16, which is just south of the proposed pad, so it's on the eastern side of the unit, is owned by that same farming family. So we knew we wouldn't be able to negotiate an SUA there. There's also a lot of RBUs within 2,000 feet. Alternative location 17 has a conservation easement on the property that prohibits oil and gas operations on the surface. The Dittmer Pad pre-application meeting included discussions about possible locations in Adams County. However, none of those locations were deemed viable. The first Adams County location, it was located southwest of the unit lands, is platted for future residential development. The second location is encumbered by the floodplain, floodway, railroad, Highway 85, and numerous large bodies of water. And the third location is located next to a densely populated DIC. Next slide. In 2019, after a thorough evaluation of the potential impacts and optimal areas for safe and effective operational practices via the ALA process, Incline selected the first Dittmer pad, which is directly east of our proposed Dittmer pad, over the alternative locations. We executed an SUA with the surface owner and began permitting the location. However, we had to abandon the site because of drainage issues and a USR that was on the property at the time, but has since been rescinded. We reevaluated the area for our next best option and found that if we could move the Dittmer pad to the far western side of the property, it would resolve the drainage issues we were previously having. The USR was already in the process of being rescinded, so we decided to move forward with the proposed Dittmer pad as our well site. Once selected, Incline participated in a pre-application meeting on September 28th, 2022, with Weld County, the ECMC, and other government agencies, giving Incline an opportunity to demonstrate how the Dittmer pad complies with the standards set forth in code while protecting the health, safety, and welfare of the community, environment, and wildlife. The location is 3,517 feet from the nearest high priority habitat, more than 2,000 feet from a disproportionately impacted community, school facility, and childcare facility, and 1,038 feet from the nearest wetland. The Dittmer working pad surface is located 2,640 feet from an inactive public water system with a deceased administrator. In 2022, the ECMC advised us that under this scenario, Rule 411 does not apply. The Dittmer pad is not located within active cropland, which is important to both landowners and the relevant local government, Weld County. The augmentation recharge ponds directly south of the Dittmer pad triggered Rule 1202A3, which does not allow new staging, refueling, or chemical storage areas within 500 feet of the ordinary high water mark without a CPW waiver, which Incline was able to obtain. The east-west development ensures no waste or stranded minerals and allows us to drill from one pad site. It has an existing access road, will be connected to takeaway pipeline for oil and gas, and has an approved 1041 WOGA and pending BLM APDs. Ultimately, the proposed Dittmer pad was chosen because it allows Incline to responsibly develop the unit lands in a protective manner while being technically and operationally feasible. Next slide. The Dittmer OGDP falls under Rule 604B1, which provides an exception to the 2,000-foot siding requirement if the residential building unit owners and tenants and high occupancy building unit owners and tenants within 2,000 feet of the working pad surface explicitly agree with informed consent to the proposed oil and gas location. Next slide. To comply with Rule 604B1, Incline obtained informed consent from every RBU owner and tenant within 2,000 feet of the working pad surface. This includes the 2 RBUs that were converted to other uses and the uninhabitable RBU. In addition, Incline obtained informed consent from 2 nearby RBU tenants that were just outside the 2,000-foot buffer. The informed consent packets were provided in English and Spanish, and a Spanish-speaking representative was made available to any party that needed it. Next slide. This slide shows an overview of our permitting timeline. No comments were received during the 30-day comment period, and no petitions were filed prior to the OGDP deadline. Incline has also received a director's recommendation for approval of this OGDP. Currently, Incline plans to begin pad construction on this location in the first quarter of 2024 and begin the interim reclamation phase in the fourth quarter of 2024. Incline will avoid, minimize, and mitigate impacts to receptors by implementing best-in-class BMPs. Once in the production phase, Incline will construct a permanent 6-foot cedar fence and berm around the perimeter of the pad site to minimize visual impacts. And the images on the slide are just 2 of the images from our visual mitigation plan that Ms. Holliday brought up. The top image on the slide shows a rendering of the aerial view of the Dittmer pad in the production phase. And the bottom picture shows the vantage point of the Dittmer pad in the production phase from RBU 6, which is the second closest RBU to the working pad surface. During drilling and completions, the site will be fully wrapped in 32-foot sound walls, and our modeling indicates that because of the sound wall placement, nearby receptors should not experience any major changes in noise or lighting. To limit light trespass, Incline will direct light downward and inward, utilize sound walls, and use LED lights to reduce sky glow. We'll avoid odor impacts by using a closed loop system and sealed tanks on location. We'll also utilize odor neutralizers and cover cuttings during transportation to ensure limited odor impacts to nearby receptors. Safety measures will include using real-time monitoring, remote shut-in capabilities, and a guard on duty monitoring who can access the location. Next slide. Incline will avoid unnecessary dust and traffic by automating the wells and production facilities and using an oil tankless facility during production. We will implement speed restrictions during high wind days, and stabilize the road to minimize impacts to nearby receptors. All traffic will exit the location west onto Weld County Road 4 and follow the approved haul route. The property directly west of the working pad surface is used for RV storage, and the owner has expressed concern about dust getting on the RVs. We have assured the property owner that we will work to reduce any dust impacts by employing best management practices, and that we will respond to and work to resolve any dust-related complaints in a timely manner. To manage stormwater properly, Incline will perform stormwater inspections at least every 7 days during operations and every 30 days after interim reclamation. We'll install stormwater controls prior to construction activities to prevent off-site migration of sediment and contaminants into nearby sensitive areas. Incline's stormwater system includes 2 trapezoidal channels ending at 1 water quality infiltration pond on site. Next slide. Using an oil tankless design during production removes thousands of post-production truck trips and eliminates the biggest emission source on location. Incline will also employ electric-powered production equipment to avoid additional emissions impacts. What emissions we can't avoid, we will minimize by using a closed-loop system, temporary ECDs on water storage tanks, that are equipped with combustion devices with a 98% destruction efficiency, Tier 2 natural gas engines with battery assist during drilling, Tier 4 equivalent or better engines during completions, and conducting AVO inspections weekly for the first year. Incline appreciates the opportunity to consult with the CDPHE. We had one consultation in September of 2023. We've committed to 50 of the 58 applicable BMPs related to air, water, waste, and PFAS. Incline will implement ambient air quality monitoring on site for a period of 12 months, use electric equipment and devices to minimize combustion sources on site, and coordinate with nearby fire districts to evaluate whether PFAS-free foam can provide the required performance for specific hazards. We have worked very hard to ensure that all surrounding community members and stakeholders have been informed about the Dittmer OGDP and been given the opportunity to ask any questions or voice their concerns. As part of our engagement, Incline has provided all required notices, including 174 completeness packets. Initial outreach efforts started in October of 2022, and we continue to engage with the community as recently as this month. Notably, we hosted 2 in-person events, and in total, we had 3 attendees, none of which included any RBU owner or tenant within 2,000 feet. Topics of conversation included timing, noise, lighting, health, and general questions about the project, such as what minerals are going to be developed. We have been in direct contact with all of the RBU owners and tenants within 2,000 feet and have engaged numerous other neighbors whose homes or property are outside the 2,000-foot buffer. We hired a bilingual landman to converse and meet with Spanish-speaking community members, made hundreds of calls and emails, and met one-on-one with numerous stakeholders to discuss the project. We will continue to proactively communicate with the community for the life of the project through the final reclamation of the wells. The only well Incline owns in the Dittmer unit is the Struck number 1 well, which is identified as the yellow star on the map, located in the northeast quarter of Section 36 in the Dittmer unit lands. The well is located on lands owned by a local mining company, but is leased to the city of Westminster for its mining operations. Because of the location of the Struck well, the city was going to have to postpone further mining operations until the well was plugged and abandoned, which we plan to do once the Dittmer unit wells were online. However, to be a good neighbor, in September of 2022, Incline decided to plug and abandon the well early to help out the city. Incline's oil and gas leases that were held by the Struck well are now HBP by third-party operators' vertical wells, which has placed considerable permitting risk on our decision to assist Westminster. As a result of the work, 1 oil tank was decommissioned, 1 acre of land was reclaimed, and Westminster could continue its operations. The table on the slide shows the emission savings from retiring the Struck well. Yesterday, we received 5 questions from the commissioners that I'd like to quickly address. The first question was whether or not we had a consultation with the proximate local government, Brighton. In November of 2022, Brighton requested a WOGLA consultation. We reached out to Brighton 8 different times to set up a consultation, but was either never responded to, or Brighton would ask for times that worked for us. And when we recommended or responded, we would never hear back. So ultimately, we were never able to set up a consultation with them. Next, we were asked to explain the consideration in the ALA process and trade-off of being near people versus having environmental impacts. During the ALA process, Incline, we did evaluate environmental factors such as the Dittmer pad and the alternative locations, proximity to and relative flow direction from water bodies and wetlands, as well as proximity to RBUs, wildlife and plant habitats, and seasonal wildlife migrations. Incline then utilized the information to identify locations that would minimize impacts to receptors and still allow for technically and feasible operations. Where impacts to receptors could not be eliminated, Incline evaluated best possible management practices and mitigation measures to avoid, minimize, or protect the public health, safety, welfare, environment, and wildlife. After a comprehensive analysis of both the subsurface and surface factors, Incline identified a consolidated number of locations. And then as far as the trade-off between impacts to people or the environment, we were really never presented with the opportunity to decide between the two. We couldn't continue our first pad because we were unable to find a location for our facility equipment. And then the Dittmer property was really the only other option because, like I mentioned, the western side of the unit is all owned by one family that would not engage in discussions for an SUA. Next, will the operator consider committing to Group 3 drilling mud? The answer is yes, we are open to committing to Group 3. Does the operator have a financial assurance plan? We do not currently have a financial assurance plan because we don't operate any wells in the state. However, we do plan on submitting the Form 3A financial assurance plan in accordance with Rule 702 C1 Option 1 at the time we submit the Dittmer Form 2s. And then lastly, can operator please confirm if the 5 wells mentioned in the cumulative impacts plan will be plugged or not? Looking back, I understand the confusion there. There are 5 remaining vertical wells in the unit that are owned and operated by 2 different third-party operators. And since we don't own the wells, no, we cannot commit that they're going to be plugged, but we brought them up because based on conversations that we've had with those operators, we expect that the wells and facilities will be decommissioned once the Dittmer wells are producing. And with that, that concludes my presentation. I'll turn it back over to Mr. Willis, and we look forward to answering any questions you guys might have.
Thank you, Ms. Friday. And I'm certain that the commissioners appreciate your presentation. The last slide, which is in your pack, is basically just the request of relief, a reiteration of that. And accordingly, Incline would request the OGDP be approved along with its proposed 1,280 acre drilling and spacing unit. Ms. Feldman and Mr. Peterson are here to support Ms. Friday as she fields any questions that you might have as commissioners. I once, on behalf of Incline, I appreciate your attention to this matter. Thank you.
Okay, thank you for the presentation. With that, commissioners, we have a panel before us that is open for questions. Commissioner Ackerman.
Thank you, Mr. Chair. I appreciate the presentation. I do have a couple of clarifying questions. I'll start with the modification on the type of drilling engines. So in the application, it had been proposed as Tier 4. And as I understand it, your proposal is to, rather than Tier 4, say we'll do Tier 4 if available, but can't commit to Tier 4, but will commit to Tier 2. And I think you said Tier 2 with battery. Did you mean Tier 2 biofuel with battery, or just Tier 2 with battery?
Tier 2 biofuel, natural gas with battery, correct.
Okay, that's what I suspected. So understood. So a minimum of Tier 2 biofuel with battery. And I noted in the presentation that you were willing to commit to Group 3 drilling fluid. I just wanted to make sure that's a firm commitment that you will use Group 3 drilling fluid.
That's correct.
Thank you. My final question then would be, I understand gas will be moved via pipeline, and after your CDPHE consultation, oil will be moved by pipeline as well. The intent is still to truck produced water, is that correct?
That is correct.
And do you know of any produced water piping infrastructure in that area?
None is available at the current time.
Thank you. And do you know, can you estimate the amount and frequency of water to be trucked from this site?
Varies greatly. As you're aware, initial production of water is high, falls off quickly, and it is in the we have done detailed traffic forecasts. I don't have them right in front of me. It tapers off to less than a load a day within a couple of years. The initial trucking load is high, and that tapers off quickly.
Thanks, Mr. Peterson. That's helpful. Do you know approximately how far that load will be trucked?
There are disposal facilities within 10 miles.
Thanks so much. That's no further questions, Mr. Chair.
Other commissioners with questions? Commissioner Messner?
Thank you, Mr. Chair. A couple of questions. One, understanding that there's informed consent that's been developed with the RBUs inside of 2,000 feet. I wonder if you could just talk a little more about that interaction in order to develop that informed consent and the type of communication that occurred with those residents.
Absolutely. So we obviously we started actually prior to sending the informed consents. We reached out to everyone. We had our first in-person meet and greet, and as we said, we only got 3 attendees total, and those and neither party was within 2,000 feet. We reached out to everyone either via email or phone calls. A lot of the southern portion of the unit are Spanish-speaking community members. And so when we figured that out, we hired a bilingual landman and provided all documentation in Spanish. We had him translate all of that to make sure what we were providing was accurate. And yeah, we just kept in constant communication. Really, the big thing that we heard was from the landowner to the west that was just concerned about RVs getting dusty during the operations.
Okay, but they were provided information on the full extent of the proposed operations before providing informed consent.
Correct.
Including the truck traffic that's going to be associated with this.
Yes, we provided the haul route and all of that information. Yes.
Okay. Thank you. I read somewhere that there was some communication that happened with the city of Brighton as far as determining a haul route or a road maintenance agreement. Am I making that up, or is that something that actually occurred?
I did reach out to Brighton's attorney about a road maintenance agreement and asked them to provide us with the template that they would like to use. And their attorney said that he would, but we never received it.
Okay. So no road maintenance agreement in place.
No.
And the haul route does go through the city of Brighton?
Yes.
Okay. I wonder if you could talk just a little bit about the discussions that happened with the electrical utility around being able to first provide electricity for production facilities, but then also a determination that there was not electricity available for drilling rigs.
Yes, sir. Thanks, Commissioner Messner. We had discussions with United Power, and those were the sum of, you summarized the discussions quite well. Power is available on the county road and to the existing facility, that sufficient to power the compressors and the equipment on the production location, but it's a significant distance to and requires a significant upgrade to bring in the sufficient 3+ megawatts to run a drilling rig. So the utility had no plans to do upgrades of that magnitude in the time frame we're looking at, and the decision was made that it was not feasible to bring power in the miles that it would take to power a drilling rig.
Okay, and so the utility provider, didn't have plans to do it, and they weren't willing to be able to conduct that upgrade, even with your ability to, offer to do that for them. Is that correct? They're just not interested in having it that far.
The temporary nature of the load was such that they weren't sufficiently interested to do the upgrade, and we did not get to the point of speccing out the detailed work that would need to be done. But due to the fact that the high load would only be there for a short period of time, it did not make sense to the utility or to Incline to do the upgrades necessary to power an electric drilling rig.
Okay. And then just so I better understand the layout here, when you're talking about the mining operations that are in the vicinity there, those are gravel pits, right? That's the mining operations that are happening in that particular area.
Correct.
Okay, and the subdivisions that are south, particularly the ones that are the most dense, how far south are those?
I believe they're more than 2,000 feet away. I don't know exactly the distance.
Yeah, I was curious if they're like 2,020 feet away, or if they're like, 4,000 feet. It was hard on the maps to get a good understanding of how far south those were.
Yeah, I can look that information up and get it to you.
Okay, and also curious about what that density actually is to the south. Is it, they appear, at least from the plats, to be a very dense subdivision, but it was a little hard to tell because some of the surrounding areas were, RV storage, and those from an aerial map almost look like trailer homes, right?
Sure.
And so it's a little hard for me from those maps to really get a good picture or understanding of what the surrounded land uses are and how far away they are. So if you could let me know that might help me better understand the layout of the surrounding areas. Because as Chair Robbins indicated, I did find it a little interesting that Weld County determined that there needed to be some additional mitigation from a visual standpoint. And it's the first time they did it. And I'm also wondering why that was. And I'm assuming it's because there was a pretty dense subdivision in a pretty close vicinity to the south, but I'm trying to better understand that.
Yeah, I can't speak on behalf of Weld County and why they chose to do that. I wish Jason Maxey was here to elaborate on that. But the surrounding area is generally industrial. There's some housing to the west and then some farming housing, obviously, to the south. But the really densely populated subdivisions are 2,000 feet plus. But I'll get all of that information to you.
Okay, thank you. That's all the questions I have right now.
Further questions for the panel? Okay, I'm not seeing further questions. Commissioner Messner, you asked some questions and they didn't get you the answers. Do you have a need to hold off on making a determination at this point in time?
Mr. Chair, there's a couple of things. So I am trying to better understand the request for intervention from the local government standpoint, because I'm also trying to better understand just what the particular concerns were of folks that seem to be just outside of 2,000 feet, and whether those are odor. And now I understand we're doing Group 3 drilling mud. That may help alleviate some of the odor concerns if it's that. But I'm not sure what the concerns were. So I do need to understand that. And then two, in my deliberations and considering potential impacts, even though I understand we've got informed consent, proximity of dense subdivisions, even outside of 2,000 feet, to better understand, appropriate technologies to be considered, are part of my deliberative process, at least as I think about this. And so it would be helpful to know, how far away we're talking those are, understanding that the industrial uses are to the north and to the east. So if we could take maybe a 5-minute break to give them an opportunity to do that, it seems like the questions I have are relatively easy to come up with answers to.
All right, let's take 10 minutes. It's 10:15. Let's return at 10:25.
Thank you.
Chair, you're muted.
Thanks. We're back. It's 10:25. Mr. Willis, do any of your witnesses desire to provide additional answers to questions from the commissioners that were presented earlier this morning?
There's been some electronic chatter back and forth between my client and her support team. I just want to ask Miss Friday on the record whether or not she's able to ascertain any answers to Commissioner Messener's questions.
Yes, Ann Feldman's going to go ahead and handle both of those.
Good morning, commissioners. Thank you. Kelly Holliday has shown herself. Kelly, do you have any additional information to present to the commission on Tara Marcellus's intervention on Dittmer OTDP?
Yes, I
Ms.
do.
Holliday?
Thank you. I apologize. I've had some technical issues and was out of the meeting for a bit, but seem to be back and good now. So in response to the letter that was received from Ms. Marcellus, as well as the application for intervention, her concerns were regarding exposure to drilling chemicals, light and noise. And she expressed that her family suffers from asthma. And through the final order, Incline has committed to a few items. And through Ms. Marcellus' testimony during the hearing, she expressed that she had not evaluated their noise plan, was not aware of noise mitigation that they intended to implement. So I think through those discussions, the noise and the lighting concerns due to sound walls were addressed. The remaining kind of for the exposure to drilling chemicals and just odors in general and the sensitivity to suffering from asthma, Incline committed to continuous air monitoring to just be on high alert for any chemicals that may be in the air or exposure to anything. And Ms. Marcellus, at the end of the hearing, seemed to be satisfied with the additional BMPs that Incline committed to. And Director Maxey is available now as well, and I think he could speak more to the requirement for the visual mitigation and how or why that came into play.
Let's bring Mr. Maxey elevated.
Morning.
Good morning. Questions have arisen with regard to this application and Weld County's requirement for additional visual mitigation. And commissioners were wondering just sort of that is not typical. And so what were the considerations that went into that request?
Yeah, thank you, Chair. So I don't want to get too far down a rabbit trail with this answer, so I hope we don't do that. But I think to understand the requirement the request that we had on the applicant for a visual mitigation plan, we have to understand some of the past. And so some of the past, which the commission and the staff at the ECMC might not even know, is that this location came before Weld County over 3 years ago for a similar proposal on this property. There were additional circumstances with the property at that time that were, I guess, not compatible in the eyes of Weld County, and this application did not move forward at that time. Due to the applicant coming back more recently with a revised plan and proposal for this location, and due to some of the additional surrounding concerns having been addressed or not on the table anymore from Weld County's perspective regarding competing land uses, this proposal moved forward. However, we felt that it was still appropriate to talk to the applicant, to talk to the applicant about doing some sort of visual mitigation due to the surrounding land uses and the area. Excuse me, my goodness, I don't know what got into me. I'm standing outside trying to do this. So that's kind of in brief why we requested from the applicant that they consider some sort of visual mitigation plan, is just due to some of the history of this application and this location, along with some of the surrounding uses that are still out there, and just the desire to try to screen it a little bit, help to visually mitigate some of the concerns, especially from what we heard with the intervention party and a couple of the other parties that called me personally during this process. That visual mitigation will also help with certain factors that Ms. Holliday already alluded to, such as some of the noise and some of the lights that will be happening on location in the permanent production phase of this location as well. So we felt that it was a unique situation based on the current situations and the history. We felt that it was appropriate. I don't think that we went overboard with it. It's nothing, like any type of 15 or 20 foot walls or anything to that nature. It's going to blend in with the surrounding area using, a partial earthen berm, as well as some privacy fence around the location that should help with some of those mitigation factors. So hope that answers the question, and happy to dialogue further with you all if you have any further concerns.
With the commitments along these lines, Weld County was comfortable in its approval as the relevant local government for this location?
Yes, if I understood the question correctly, yes, we're definitely comfortable with it today. Again, there was a competing land use in the past that was a little bit of a different situation. That competing land use is no longer valid. It is now completely gone. So the main concern that we had 3 years ago or so is not even a factor these days. We agree with what the director's recommendation on your side referenced. We agree with certain things that Ms. Holliday has, in my understanding, already testified today regarding mitigation factors that were implemented during our process, along with some of the other referral agencies such as CDPHE that the applicant has agreed with. So we don't find any conflict from a local standpoint anymore, and we would fully support this.
Great. Questions for either Ms. Holliday or Mr. Maxey before we turn back to the applicant? Great. Again, appreciate Weld County's participation with us. Ms. Friday, Ms. Feldman, did you have anything further?
Not regarding the intervention, Chair Robbins. I can address the distances that Commissioner Messner had requested. The larger subdivision to the southwest is approximately 4,850 feet from working pad surface. There is a smaller subdivision to the southwest that is approximately 2,700 feet from working pad surface.
Thank you. Thank you for providing that information. That does change the perception or picture of the location, and that's helpful for me. So thank you.
You're welcome, Commissioner.
Okay, further questions for the panel? All right, we're not seeing further questions. Do we want to move into deliberation phase? Commissioner Cross?
Thank you, Mr. Chair. I'll start off saying that I'll admit I had some questions going into today. I do think that the applicant did answer a lot of the questions that I had coming in. I do appreciate a lot of the BMPs that they are agreeing to. I think that the oil takeaway was a big one to me that I think was important, getting rid of some of those truck trips, especially in this area, especially avoiding truck trips, given that they'll have a lot of proximity to the city of Brighton, to developments going on, as was just discussed with both the 4,800 feet and the 2,700 feet. So I think the reduction in truck traffic trips was also very important to me. I also thought it was important to have some updates with respect to the financial assurance. I definitely did have some questions on that, so it was good to see some answers there as well. Overall, I do think that, in my opinion, this is an approvable application. I appreciate the depth that was shown about the alternative location analysis. I appreciate the steps that were shown to try and make sure that they could go above and beyond. You know, I thought it was helpful discussing the fact that they took extra steps to make sure that when they found out that there were Spanish speaking citizens in proximity, that they were making sure they were working with translators and interpreters for that purpose, because I think that is important to make sure that they understood before signing any informed consent. And additionally, I think the informed consent was important to me as well. So I do think that I hope moving forward that some of these questions are answered more in the initial application and not having to be kind of drawn out in our actual hearing process. But overall, I do think that the steps that the applicant is taking with a lot of these BMPs to make sure that they're using the battery assist with the tier 2 natural gas rig, the oil takeaway via pipeline, et cetera. I do think that these are important, and I'll be in favor of this application.
Thank you, Commissioner Cross, for starting deliberations for us. I'm in largely agreement with you. I think that the fact that we've got informed consent for the 6 RBUs is important. The movement away from tanks into the oil pipeline also is important. Understand that we would like to have water takeaway via pipeline if possible, and I believe they've explained that that's not possible in this instance. That's going to happen at times, and so I don't believe that that triggers any non-application of a rule relevant to this application. Appreciate the additional information about the location of the subdivisions as well as the gravel pits nearby. I am largely in support of the application as presented. Further deliberations. Commissioner Messner.
Thank you, Mr. Chair. You know, this is an application that is in proximity to RBUs inside 2,000 feet. I think that, you know, the applicant did a good job of obtaining informed consent in this particular situation, and I think that largely is going to influence my ultimate decision here. I will note that even when applicants gain informed consent, there's still a requirement to ensure that operations that are being proposed are protective and meet our rules. I think generally, especially with the modifications that were made here, that this application does do that. I will note that I'm not sure that I would have approved this application without oil takeaway in this particular situation. I think that in this situation, the oil takeaway was an important piece for me. And I think also an understanding that in the particular situation where you've got proximity to homes, having the Group 3 drilling mud ends up being a big consideration as well from an emissions standpoint. In my conversations with CDPHE, determining kind of a criteria of things that are most important to be able to address when in proximity to homes is, number one, to ensure there's tier 4 or better diesel engines associated with completion activities. And behind that is actually the type of drilling mud that's utilized as far as emissions that are associated with that. And so now that we've got tier 4, or there has always been commitment to tier 4 diesel engines and completion activities and the utilization of Group 3 drilling muds, it does certainly make me more comfortable with the proximity to homes. You know, I think that the commitment to natural gas drilling rig with a battery backup is an appropriate solution to a scenario where there may not be proximity or availability of electricity. I'll continue to ask operators, though, to be clear as to whether they're choosing not to do electricity because of cost, or whether they're choosing to not do electricity because there is just not capacity available. It's a little unsure to me in this situation whether it was a cost thing or whether it was just not available. But I do believe, because of the informed consent that was developed, that the utilization of the drill rig as proposed is appropriate in this particular situation. And I think that the surrounding land uses associated with this, particularly with the proximity of the subdivisions to the south being 2,700 square feet or 2,700 feet or more, you know, and industrial and or commercial activities that are surrounding this make it an appropriate location for this particular well pad. So I will be in support of this, but wanted to make sure that I had my findings on the record as to why.
Commissioner Ackerman?
Thank you, Mr. Chair. I think I don't have anything to add that hasn't been already stated by you or Commissioner Messner or Commissioner Cross. I think that was well summed. I particularly agree with Commissioner Messner's comments about the modifications to this application, moving it over, in my mind, to an approvable application. That said, I'm willing to make a motion if it's time, Mr. Chair.
Please.
I'll go ahead and make a motion to approve this application. My understanding, and I might need Assistant AG Mercer's help on this, but my understanding is that that motion would include the use of Group 3 drilling fluids, oil takeaway via pipeline, and an engine that has the minimum emissions profile of Tier 2 natural gas biofuel engine with battery engine management system. Did I miss anything there, AAG Mercer?
Thank you, Commissioner Ackerman. No, that covered it all. The other change that the operator daylighted was the tankless design of the facility, but the Form 2A already reflects 0 oil tanks, so I don't believe that needs to be added. It should also need not be a part of the motion, but would be perhaps helpful to give direction to the applicant and staff to work together on revising the Forms 2A and 2B to ensure that they both cover all of these changes.
Thank you, AAG Mercer. It might be appropriate, Mr. Chair, to make sure that the operator agrees that I've reflected the conversation appropriately as well.
Yep. Mr. Willis, you comfortable with the motion as articulated by Commissioner Ackerman and AAG Mercer?
Yes, thank you. Yes.
Very good. Motion and a second. Is there further discussion?
Mr. Chair, I will just note that I do encourage the operator to continue to reach out to the city of Brighton to discuss, you know, haul routes that are going through that jurisdiction, and potential road maintenance agreements that could be associated with that, because the understanding that there is no produced water pipeline taking this off of site, the amount of truck traffic that'll occur within that jurisdiction in the first couple of years is significant, and I think continues to warrant coordination with that municipality.
Okay, so noted. Further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. Thank you, Mr. Willis, to you and the panel, as well as to our staff for the good work in developing this application for presentation to us.
Thank you, Chair.
Rather than us sitting around waiting on the next matter to get docketed, let's take 5 minutes, and during that 5 minutes, if we could get docket 2212-00379 up and running, that would be great. Note for the record, Commissioner McGowan has joined us. We're taking 5, Commissioner McGowan, before we take up the next docket. We're back. We're getting started with the recording. At this point, I would call upon AAG Mercer to swear in the multiple witnesses that are on the screen.
Sorry about that. Hi, everyone. I'll go one by one in the order that you appear on my screen and just ask you to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Mr. Eby.
My name is David Eby. I swear to tell the truth.
Thank you. Mr. Bowen?
My name is David Bowen. I swear to tell the truth.
Thank you. Ms. Vogel?
My name is Patty Vogel. I swear to tell the truth.
Thank you. Mr. Joby?
My name is Patrick Job. I swear to tell the truth.
Thank you. Mr. Falk?
My name is Steve Falk, and I swear to tell the truth.
Thank you. Mr. Gendelman?
My name is Igor Gendelman, and I swear to tell the truth.
Thank you. The other Mr. Gendelman?
My name is Edward Gendelman, and I swear to tell the truth.
Thank you. Ms. Gross?
My name is Andrea Gross, and I swear to tell the truth.
Thank you very much.
Ms. Wazelinski, though.
Thank you. Thank you. We also have Mr. Scott Davies, who may answer a question. He's not presenting today. I know his video is not working, but we may want to swear him in via audio, if that's okay.
Thank you. Yes, Mr. Davies, even though we can't see you, I'll just ask that you raise your right hand, state your name, and that you swear to tell the truth.
My name is Scott Daves, and I swear to tell the truth.
Thank you.
Thank you. We will get our PowerPoint up and I will get started. Great. Good morning, commissioners. My name is Kelsey Wazelinski with Jost Energy Law. And with Jamie Jost, we represent WaveTech Helium in the Hillman Harker Helium OGDP before you today in docket 2212-00379. We would like to thank Karen Voltura for her guidance and efforts on behalf of CPW, Cheyenne County for their support of the OGDP, and also ECMC staff and the director for their efforts on this OGDP. I would also like to mention that we appreciate the commissioner questions that we received yesterday, and we do plan to address these at the conclusion of the presentation. Next slide. And Andrea, we can see your, there we go. You just move on to the second slide. That looks great.
Okay, thank you.
And I think you just need to advance it to the next slide. Perfect. So this OGDP requests approval of an approximate 640-acre oil and gas development plan for the development of 2 new vertical wells to target helium gas in the Morrow V3 sandstone formation. The 2 requested Form 2As are for the number 1 WaveTech Hillman Family Trust 43-15 pad and the number 1 WaveTech Harker Family 31-22 pad as shown on this map. WaveTech will utilize 2 320-acre drilling and spacing units established by Order 477-3 for the targeted Morrow V3 sandstone. All gas produced from the Morrow Reservoir will produce directly to the existing Ladder Creek pipeline system. WaveTech does not expect to produce oil as part of this development. The 2 proposed locations are located within Cheyenne County. Cheyenne County does not regulate the siting of oil and gas locations. However, WaveTech has been in close communication and consultation with Cheyenne County throughout the OGDP process and has the county's full support. WaveTech also had extensive consultation with CPW and U.S. Fish and Wildlife as part of this OGDP. The locations are within the Lesser Prairie Chicken Estimated Occupied Range, or EOR, which encompasses almost all of Cheyenne County. WaveTech will discuss the status of its comprehensive wildlife mitigation plan in the presentation today. WaveTech's alternative location analysis and protective BMPs will also be covered in the presentation. And finally, WaveTech has complied with all notice requirements for the OGDP. No formal petitions were filed and no public comments were received on the Form 2As. And with that, I'll turn it over to Igor Gendelman, the Vice President of WaveTech, to continue the presentation.
Thank you, Kelsey. Good morning, commissioners. My name is Igor Gendelman, and I'm the Vice President of WaveTech Helium. I appreciate the opportunity to present the Hillman Harker Helium OGDP. Next slide, please. This is WaveTech Helium's 3rd hearing in front of the commission, but I will still emphasize a couple main points of introduction. Helium is an essential element for multiple essential industries and applications, and it's in short supply right now. Helium production in potential southeastern Colorado is still very large, and it can be utilized with a very small environmental footprint. WaveTech staff has a lot of experience in this area, and we are leveraging it in our efforts to deliver more very much needed helium. I would also like to note that Steve Falk, who assisted with our wildlife mitigation plan, is at the hearing and ready to answer questions. Next slide. This is an overview of the Hillman Family Trust 4315 pad location. We plan to drill one conventional vertical well at this location, which will produce helium-containing natural gas and water. All the gas production will go to an already existing Ladder Creek plant through an already existing pipeline system. This location is fee surface and fee minerals, with total drill and pad disturbance of about 3.5 acres. It's within the Lesser Prairie Chicken estimated occupied range, and we engaged in Rule 309 consultation with CPW and conducted ALA. This location is more than 2,000 feet away from all residences, buildings, and schools, and the closest town is Arapahoe, and it's about 12 miles away. Next slide, please. This is an overview of Harker Family 3122 pad location, and all the bullet points for this location are exactly the same as they are for the previous location. Next slide, please. Targets for both wells are more fluvial channel sandstones. The reservoir is highly permeable and is part of a separate gas accumulation. These locations were spaced by order number 4773. Next slide. This is the permitting timeline. WaveTech will continue to work with ECMC staff on process improvements for improved completeness timing. Next slide. This shows phases of operation. Pad construction will take about 4 days per location. We will drill 2 new wells, and they will take about 14 days each. And basic production equipment will be installed if the wells are productive. All the gas will go into already existing pipeline. Next slide. This shows the estimated occupied range for the Lesser Prairie Chicken. This EOR triggers Rule 309 CPW consultation. Next slide. All the locations are approximately 2.7 miles from the closest 1.25 mile leg buffer. They are not within a focal area or connectivity area. These are farmlands, so no grassland habitat will be disturbed. We consulted with Colorado Parks and Wildlife with U.S. Fish and Wildlife Services technical assistance. Next slide. As you can see from the slide, this area has a lot of wind turbines. U.S. Fish and Wildlife Services has suggested that lesser prairie chickens may avoid otherwise suitable habitat within 1,800 meters of a turbine. Our locations will have multiple turbines next to them. Next slide, please. Following the directive from the Commission at our first hearing, WaveTech engaged an expert biologist to prepare a comprehensive wildlife mitigation plan to cover our first 5 OGDPs and high priority habitat, to be amended as new OGDPs are filed. This slide shows various stages in the making of this plan, and this plan is now approved by CPW. Next slide, please. WaveTech has provided alternative location analysis for this OGDP. Alternative locations trigger the same criteria as the proposed locations. There is no alternative location that can reach the proposed mineral development that is not located within the Lesser Prairie Chicken estimated occupied range. CPW and ECMC support the proposed locations. Next slide. Best management practices matching all the ones for our first two GDPs will be used for these locations. Now I'll pass this presentation on back to Kelsey.
Thank you, Igor. We'll move to the next slide, please. So to summarize the Hillman-Harker Helium OGDP and WaveTech's request for approval, we note the following OGDP highlights. Cheyenne County was consulted and does not regulate the siting of oil and gas wells. WaveTech had extensive consultation with CPW, including coordination with U.S. Fish and Wildlife, and has finalized a comprehensive wildlife mitigation plan with CPW for prior approved OGDPs, this OGDP, and future OGDPs. CPW supports the siting of the two proposed locations. The director recommends approval of the OGDP. And finally, the siting and BMPs provide protection of public health, safety, welfare, the environment, and wildlife resources by avoiding, minimizing, and mitigating adverse impacts. Next slide. This slide shows the relief requested for the Hillman-Harker Helium OGDP. We respectfully request approval of the requested OGDP and associated Form 2As. This does conclude our presentation, so we can take the PowerPoint down, please. We did receive a few commissioner questions yesterday afternoon, and Chair, we're happy to address those now if that would be helpful.
Yes, please go ahead.
Great. So the first question related to plans for produced oil, if any, and I'll have Scott Davis go off mute and answer that question, please.
Okay, in general, we will have a tank and a separator that would handle any oil production that were there. So we don't anticipate it, but we felt it's appropriate to have those pieces of equipment on location once we're finished.
Thank you. And Scott, could you just explain a little bit about the V3 Morrow and whether that has any oil expected to be produced?
We don't expect it, but you know, it's in an area where there are condensate production type wells. So there is that random possibility. And I think a geologic explanation might be even better than mine.
Thank you. And commissioners, if there's any questions, additional questions on this first point, we're happy to address it with the larger group here. I'll move on to the second question, and that's asking for details regarding the gas processing facility. And I'll turn to either Igor or Ed to answer that question, please. And Igor, please. Thank you.
Yeah, all the gas will go into existing pipeline system, which will take it to Ladder Creek plant, which is right next to Cheyenne Wells, the town of Cheyenne Wells. And there, the gas will be separated into helium, hydrocarbon gas, and natural liquid gas, and nitrogen. Those are the main components. And the natural gas, liquids, and helium will be sold, and nitrogen will be used for cooling purposes at the plant.
Thank you. The third question asked about learning more about the future development plans in terms of number, general spacing, and timing, and any information on future plans that can be shared for development in the Cheyenne County area. I'll start with this one and then turn it over to Igor. So we are working to coordinating a meeting with Director Murphy to discuss this per Commissioner McGowan's comments at a prior hearing. I did just speak to Julie just moments ago, and we're going to wait until there's a permitting manager and in place to have that conversation, but we are in the process of scheduling it and hope to have that soon. As of today, 2 OGDPs have been approved. This is number 3 before you today. Number 4 is scheduled for hearing in January. A 5th OGDP that we've internally named number 6 is pending completeness review. And then the 6th OGDP, which we've internally named number 5, will be filed soon. There are number 7 and 8 will follow shortly. So as of now, we can, we can discuss the fact that there are 20 locations that have either been approved, are in process, or soon to be filed. And those are or will be covered by the Comprehensive Wildlife Mitigation Plan. So again, we're happy to continue that conversation with Director Murphy and staff. And I'll turn it over to Igor if you have any other comments on future locations.
Yeah, beyond the 20 locations which Kelsey mentioned, we don't know where the future locations will be. It takes our geologists quite a bit of work to interpret the data and model the geology, which determines our locations. So beyond the first 20, the future locations are unknown at this stage.
Thank you. And the
Thank you
last
for
question.
this. Go ahead.
Oh, thank you. We did have one other question that I wanted to address, and that's on any information related to a comprehensive wildlife management plan, especially for areas outside of the wind turbine buffer areas. So Steve Falk, who's our expert in this area, I believe is ready to address that question.
Thank you, Kelsey. Excuse me. As Kelsey just described, the plan to be revised as new locations are proposed. And as far as dealing with some of those locations that may be outside of the wind turbine buffer that's described as making habitats unsuitable, the plan currently addresses one site that falls under that category. And we consulted directly with CPW on that site, and the operator agreed to implement a drilling timing stipulation for that specific site, and that's described in the plan. So hopefully I'm addressing the question. If I haven't, please let me know.
Thank you, Steve. Chair, that does conclude our presentation and answers to the questions, and we're all here and available if you have any additional questions.
Great. Thank you very much. I, as one commissioner, appreciate the reach out to Director Murphy, and also appreciate the operator's willingness to, even if you're not looking at this from a comprehensive area plan, the important component here is the wildlife. And it seems that the operator has done a good job of working with Karen Volterra of CPW to try to address comprehensively the wildlife issues associated with the approved and to be adjudicated proposals that are coming in the future. So I appreciate that point. I think that's important. Commissioners, we have a panel before us that are open for questions. Commissioner Ackerman.
Thank you, Mr. Chair, and I appreciate the presentation today. And as these continue to come in, I continue to closely monitor the situation with lesser prairie chickens. So far, as stated, all of these wells have been within impacted wind turbine zones. I just wanted to make one point of clarification on this point as you continue to have those conversations. And Mr. Falk, you mentioned that you do have one coming up that's going to be outside of that potential impacted wind turbine zone, and that you contacted Dr. Volterra with CPW. There's a little bit of kind of mixed language in the materials, and wanted to ensure that everyone recognizes that these are not only state of Colorado listed threatened species, but also is a distinct population segment that's listed as threatened federally under the Endangered Species Act. And so I wanted to clarify that you're also coordinating and communicating with the Fish and Wildlife Service on each of these, and particularly that one that's going to fall outside of the zone that's within wind turbine impacted areas. Is that correct?
Yes, sir, it is. And I'll add to that as each ODP, proposed OGDP, meets its certain regulatory threshold is when we engage the Fish and Wildlife Service. And in each instance to date, Fish and Wildlife Service has responded with their opinion of no impacts to any protected or listed species.
Understood. Thank you. And my estimation would be that that response is likely to be different from them when it's outside of the wind tower impacted zone. And so I'll look forward to hearing their comments and seeing extensive consultation with them on that one. Go ahead, Mr. Falk,
Can I add one more comment?
please.
Your last statement, I don't want to correct it, but I want to give you a different understanding. We did submit a request for their review for an OGDP that included a site that was not within 1,800 meters of a wind turbine, and their review and their findings was reported as no impact.
Thank you, Mr. Falk. I appreciate that clarification. As far as fresh water being trucked to the location, can you elaborate a little bit? That might be Mr. Gendelman, on the amount of water being brought in, the distance that it's being brought in, and the frequency with which it will be brought.
It's gonna be brought in from Cheyenne Wells, which is the town nearby. The quantity, Andrea, do you remember how much water we bring in for each location? I don't have the number in my head.
I'll look it up right now.
Yeah, it's not a significant number, but Andrea knows the exact number.
Thank you. So I would note that Cheyenne Wells, I think, is roughly 15 miles or so from these sites. Ms. Wazelinski, I think you addressed this, and I may have missed it, but will this the product from these wells be sent to the same processing facility as the other Wave Tech wells that we've discussed in the past?
That's correct.
I thought you had touched on that. Thank you. And I don't know if Ms. Gross needs more time, and if she does, Mr. Chair, I'm happy to move on at this point.
I am ready. Thank you for giving me that time. We have stated that it's approximately 2,000 barrels of water per location, per vertical well.
And that's for the drilling, and then add to that fresh water that'll be brought in for dust suppression as well, correct?
Correct.
All right. Nothing further, Mr. Chair, at this point.
Further questions for the panel? Commissioner Messner?
Thank you, Mr. Chair. Just a couple of questions, because I guess the explanation on the potential for oil and produced water and what's going to happen with that was pretty unclear to me. And so currently there's proposed a tank on site in order to be able to capture any oil that comes out. And then if there is oil that is produced, then that is getting sent somewhere, and is that oil being sold?
Yeah, in case we do produce oil, it will go into the tanks on location, and then the trucks will haul it away. So it will be sold at the location. And I don't know where the trucks will take the oil. I don't know what the final destination is, but the oil in this area is usually handled this way. Trucks come and pick it up.
Understood, but it is intended to be sold, correct?
Correct.
Yeah. Okay. And then second question is the produced water, I mean, is there anticipated produced water in these formations as well?
Yes.
And that's intended to be trucked away as well. And what kind of truck traffic were we looking at there?
Yeah, we'll have very little water, but whatever we'll have will be trucked away to there are wells where this water can be disposed of, and Andrea may even name the precise location. I don't have it in my head.
Yeah, and I'd like to say that we have anticipated that it may be 1 to 2 times a week that water would have to be hauled off location. And right now we have it going to a saltwater disposal facility as the Coke 11-7. And I believe that is actually in Morgan County, but we'll utilize mostly state highways all the way to it.
Okay. And the last question I have, and just because I'm curious, I guess my understanding is that the comprehensive wildlife mitigation plan had not been fully evaluated by CPW and approved, but I think I'm hearing here that it has been, and so I'm just confirming that, because I guess I'm hearing 2 different things on that.
I'll take that. Yes, it was approved just after the last WaveTech OGDP hearing that you all heard. It was the Burlington Rosa. Karen Valtura gave us the approval for that. It has been given to ECMC staff so that it can be attached to these Form 2As, as well as we've reached out to see how they would like us to attach them to the other 2 locations, 2 OGDPs, so they can be on record for those as well. But yes, it has been approved.
Thank you.
Further questions? Commissioner Ackerman?
Mr. Chair, sorry for the repeat here, but one of Commissioner Messner's questions and the responses prompted another clarification for me. Ms. Gross, I think you mentioned that the disposal is taking place in Morgan County. I think you said right now we're doing it in Morgan County. Morgan County is approximately 170 miles one way from the site. Are there opportunities for closer disposal, or did you mean to imply when you're saying right now that you're looking for other opportunities?
We can look at closer opportunities. This one is, I believe, the closest one that would be able to take, it's a commercial saltwater disposal well, but we'd be happy to review what else may be available in the area. There are some private saltwater disposal wells, but they're not open for commercial disposal.
Thank you, Ms. Gross. I appreciate you offering that. I certainly would be interested in examining closer opportunities if possible.
Yeah, we will do that. There may be closer locations. We will look into that prior to producing water.
Thank you, Mr. Gendelman. Thanks, Mr. Chair.
Further questions from anybody? Does anyone care to initiate deliberations on this application? Commissioner Messner?
Thank you, Mr. Chair. I'll start by saying that I believe this is an approvable location. I think that, you know, we've seen a few of these now. I think that I continue to see a concern, you know, about kind of the proliferation of single well pads with access roads associated with it and high priority habitats. Generally, long-term, big picture. At the same time, I really appreciate that the applicant is working with CPW and it sounds like the Fish and Wildlife Service in order to be able to develop a comprehensive wildlife mitigation plan and be able to, you know, evaluate and address the potential impacts here. You know, it does feel a little bit like we've taken a step back 20 years in the spider web of roads and well pads for single well pads that we used to see, particularly in more rural areas where wildlife impacts, you know, occur in helium type development. But I think that there are opportunities here to be able to proactively address potential wildlife impacts of these types of development. And so again, appreciate the work with CPW on that. I mean, my understanding of the situation certainly is that because the windmills are in place right now, that actually provides significant cover for opportunities like helium because of the impacts that those windmills have on wildlife. And that if opportunities or sites are started to be looked outside of those impact areas, that they may have different requirements associated with how you're going to be able to avoid, minimize, and mitigate wildlife. And I think that just needs to be known. I think my understanding is that the prevailing reason that there's lack of wildlife impacts really are that previously cited windmills are having significant wildlife impacts already. And so with that, I would move to approve this particular application. And I don't have any other thoughts. Thanks, Mr. Chair.
Ms. Gross has raised her hand.
I'd like to make a clarification. I misspoke. The saltwater disposal well is actually in Lincoln County, not Morgan County, which is much closer to Cheyenne County. We're still definitely willing to look at closer options, perhaps within Cheyenne County, but my apologies for misspeaking there.
Okay, thank you for the clarification. We have had some deliberations. I am in agreement with the Commissioner Messner that this is approvable. Appreciate the good work on the wildlife component, which is the most important, and encourage that dialogue with the director once we get our planning permitting manager on board. That will be a good next step. Further thoughts on deliberations, or do we have a second? Commissioner Ackerman.
Thanks, Mr. Chair. I'll go ahead and second, but I would agree also with your statement that of these, likely the item that we need to be most sensitive to are lesser prairie chicken. Lesser prairie chicken have a very long and storied, and not just natural history in this area, but legal and regulatory history. More recently, much work has been done to conserve lesser prairie chicken in this area. And just want to make sure that I'm on record stating that I'm watching very closely and I'm very sensitive to the impacts of lesser prairie chicken to all, not just this operator, but any drilling that takes place in their estimated occupied range. Appreciate Mr. Falk and his work on this issue. And I'll second that, Mr. Chair.
Okay, good. We have a motion and a second. Is there further deliberative thoughts before we take a vote on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Ms. Wozlinski. Thank you, Karen Volterra, and to staff for advancing this matter to us.
Thank you.
All right, commissioners, here's our order of play. We're going to take up one more docket this morning, the Red Hawk Petroleum, and then we're going to take a lunch break, and then we'll take up Bayswater exploration, and then we've got 2 on the agenda for tomorrow. So let's take, say, 5 minutes now to get the Red Hawk Petroleum up and running, and then we will a review of that. All right, commissioners, we are back. It is December 13th, and this is the Colorado Energy and Carbon Management Commission business docket. We're going to take up docket 230500185, Red Hawk Petroleum LLC Oil and Gas Development Plan. I see we have Ms. Jost as the applicant's attorney. We also have Ms. Holliday from Weld County. Typically, we hear from Weld County first. So, Ms. Holliday.
Thank you, Chair Robbins. Good afternoon, commissioners, and thank you again for the opportunity to speak with you today regarding Weld County's process on the Red Hawk Petroleum Roth 2-11 Oil and Gas Development Plan. Weld County's Oil and Gas Energy Department held a pre-application meeting for the Roth 2-11 pad on January the 25th of 2023, at which time several alternative sites were discussed. Attendees included the Weld County staff, Red Hawk Petroleum, as well as their consultant, Upstream Petroleum Management, the ECMC staff, and BLM staff. CPW and CDPHE were invited, but were not in attendance at this meeting. All of the attendees and invitees did receive copies of the pre-app meeting minutes. The initial 1041 WOGLA application was received on May 23rd of 2023. And after further discussion with Red Hawk to clarify and enhance certain items, the final application version was submitted on July 20th of 2023. The application included an analysis on 4 alternative sites, which were reviewed and discussed in detail with Oil and Gas Energy staff and the hearing officer. There is one building unit as defined by Weld County Code within the 1041 Wogula zone. Weld County did not receive any public comments regarding this application, nor did we receive any applications for intervention to participate in our hearing process. The 1041 Wogula hearing was held on September the 7th of 2023. The hearing officer considered testimony at the hearing, and at the conclusion of the hearing officer found the application to be compliant with Weld County's code requirements, therefore approving the permit. The final order was recorded with the Weld County Clerk and Recorder on September the 11th of 2023 and subsequently published in the Greeley Tribune on September the 15th of 2023, creating a vested property right. From a land use perspective, this is a good location as it is close to other oil and gas development. The 2A comments were submitted to the ECMC on October 26th and are included in the director's recommendation. Weld County agrees with the director's recommendation and supports approval of this permit application. That's all I have for you today. I'd be happy to answer any questions.
Questions for Ms. Holliday? As always, we appreciate Weld County's involvement with us as the relevant local government. It's helpful for our consideration. With that, I would recognize Ms. Jost, and as is normally the case, if she would have her witnesses elevate themselves, visualize themselves, turn off their mute buttons, and we'll have Ms. Mercer swear them in.
Great. Thank you, Chair. If everyone can come on screen, please. Ms. Mercer, we have a whole host of folks, so it may take just a minute. Okay, and Mr. Cooper, can you come on screen, please? All right, Ms. Mercer, we have everyone.
Thank you very much. So welcome panelists. I'll just go one by one in the order that you appear on my screen. I'll ask you to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Mr. Boyd.
My name is William Boyd, and I swear to tell the truth.
Thank you. Mr. Hinojosa.
My name is Charles Hinojosa, and I swear to tell the truth.
Thank you. Mr. Clutho.
My name is Jim Clutho, and I will tell the truth.
Thank you. Ms. Gross.
My name is Andrea Gross, and I swear to tell the truth.
Thank you. Mr. Musso.
I'm Johnny Musso, and I swear to tell the truth.
Thank you. Mr. Lawrence.
My name is Errol Lawrence, and I swear to tell the truth.
Thank you. Mr. Hagerman or Hagman? Oh, you're muted.
There you go. Name's Neil Hageman, and I swear to tell the truth.
Thank you. Mr. Cooper.
My name is Ken Cooper, and I swear to tell the truth.
Thank you, everyone.
Excellent. Thank you so much, Ms. Mercer. And Chair, if I could just ask Ms. Gross to pull our PowerPoint up, and then I can start in. All right, and then everyone outside of Mr. Boyd and I, feel free to go ahead and go off screen.
Amy?
Yes.
Are you seeing the full presentation or just the?
Just the main, and now it's the double slide. So if you could go to full, that would be great.
Okay. Is that better?
Yep, you got it. Thank you so much.
Thank you.
All right, Chair, if I may.
Yes, please.
Okay, great. Thank you. Good morning, commissioners, staff, members of the public. My name is Jamie Jost of Jost Energy Law, and along with my partner, Kelsey Wieselinki, we represent Red Hawk Petroleum in the Roth 2-11 OGDP application before you today in docket number 2305-00185. With me today are Mr. William Boyd from Red Hawk, Mr. Charles Hinojosa from Red Hawk, and Ms. Andrea Gross from Upstream Petroleum, as well as other subject matter experts that will be available during the questions portion of the hearing. We look forward to presenting this OGDP application to you today. Next slide, please. Red Hawk operates 17 wells in the state of Colorado. However, this is Red Hawk's first OGDP application to come in front of this commission under our mission change rules. Red Hawk would like to specifically thank the ECMC staff and director for their guidance and efforts on this OGDP. And we'd also like to thank Weld County for its participation through the local government permitting process and the approval of the WOGLA for the oil and gas location subject to this OGDP. I will provide a short overview of the application and then turn it over to Mr. William Boyd. Red Hawk's Roth 2-11 OGDP application requests approval of a 2,560 acre oil and gas development plan with 2,560 acres of minerals to be developed from one new oil and gas location. And again, this is the Roth 2-11 pad, which is located in Section 11, Township 7 North, Range 60 West in northern Weld County, Colorado. The Roth 2-11 pad will be a multi-well oil and gas location that will house up to 11 new horizontal wells for the development of the Niobrara Formation from two 1,280 acre drilling and spacing units. DSU number 1 is an established 1,280 acre unit that consists of sections 2 and 11, and we're seeking to drill up to 5 new wells under existing commission orders. And DSU 2 is a new 1,280 acre drilling and spacing unit that consists of section 14 and 23, and Red Hawk is seeking to drill up to 6 new wells in this unit. Both DSUs are seeking 300-foot subsurface setbacks to correspond with the existing 300-foot setbacks already established in sections 2 and 11. As Ms. Holliday said, the Weld County WOGLA was approved in September of 2023 and has been recorded in the county records. Red Hawk has engaged in extensive consultation with CPW on the proposed location, and we will address that in our presentation today. In terms of the OGDP submittal, Red Hawk complied with all notice requirements for the OGDP, no formal petitions were filed, and no public comments were submitted on the Form 2A. The director has recommended approval of the Roth OGDP, and Red Hawk respectfully requests that this commission also approve the Red Hawk Roth 2-11 OGDP. We did receive 4 commissioner comments prior to the hearing, and we will address those at the end of our presentation. With that, I'd like to go ahead and turn it over to Mr. William Boyd to present this OGDP application today.
Thank you very much, Ms. Jost. Good morning, commissioners. I'd like to begin by thanking you very much for taking the time to hear our application this morning. My name is William Boyd. I serve as the Land and Regulatory Manager for Red Hawk Petroleum. I've been in the oil and gas industry, serving as a landman or a regulatory capacity for approximately 12 years. So slide, please. We're on the surface highlights. This is, like we said, going to be incorporated in a singular new surface location. We've worked with the surface owner to execute the surface use agreement and have received approval from Weld County. We anticipate approximately 9.5 acres of surface disturbance for the construction of the pad during the drilling and completion operations, and interim reclamation should reduce the size of that pad to roughly 3.5 acres during the production phase of the wells. TDPEG was offered but declined consultation. We did receive 5 best management practices from Colorado Parks and Wildlife. We went through the alternative location assessments because we are within high priority habitat for the pronghorn antelope. There are no residential buildings within 2,000 feet of the proposed location. We are also outside of any disproportionately impacted community, more than 1 mile from a school or child care center, DOAA, or public and surface water supply areas. We also anticipate that there should be no impacts to floodplains or wetlands. Slide, please. Here we have the mineral highlights that we can develop. 5 new 2-mile horizontal wells and 6 2-mile horizontal wells to the south in the DSU number 2, with the first DSU being sections 2 and 11, and the second being sections 14 and 23, all of which is fee mineral ownership. We should control approximately 71.5% of the working interest in DSU number 1 to the north, and just a shade over 46% in DSU number 2 to the south. Slide, please. Just an idea of the brief operational timeline from a high level viewpoint. We've, after consulting with Parks and Wildlife, agreed not to begin construction until May 1st so that we can maintain our operations outside of any stipulation window that may occur, putting that in the second quarter of 24, with drilling to commence immediately thereafter. We anticipate that the completions will follow drilling, and it should be either on the second or third quarter. So we've noted here that it would be in Q2, as it would be the earliest possibility for the beginning of completion operations. But that would certainly put initial production in the third quarter of 2024, with the beginning of interim reclamation, hopefully in the early Q4 of 2025. Slide, please. As previously mentioned, the relevant local government is Weld County, and they have been consulted. We had our pre-application meeting in January of 23. That's a little bit of a typo that we found. It certainly wasn't on New Year's Day, 2023. It was later in the month, which was also attended by Weld County and ECMC staff. The Wogler hearing was held in September and approved at the conclusion of the meeting, with the order being recorded, as you can see to the right of the slide, on September 11th of 2023, creating that vested local property right. Slide, please. So it's important to know that this is within a non-attainment area. Therefore, we did reach out to CDPHE for consultation. As you can see on the slide, there are no RBUs or within 2,000 feet, but CDPHE did decline any formal consultation due to the fact that it is a fairly remotely located pad site and not within any disproportionately impacted community. Slide, please. We did consult quite thoroughly, actually, with Colorado Parks and Wildlife, with the initial on-site consultation, occurring on March 21st of this year, with additional consultations held via Zoom. We did commit through CPW to 5 best management practices. You can see listed below. Most importantly, I believe, being that we've agreed not to conduct any operations during the stipulation window of January 1 to April 30th, putting the beginning of our project operations at May 1st of 2024. The others are, I think, fairly standard practices that we're happy to employ just to ensure that we can minimize any wildlife impacts through our operations. Slide, please. Okay, so now we'll jump into the alternative location analysis. You can see here on the slide the 4 different locations that we had considered. But before I go too far into this, I think it's important just to point out that you can see the horizontal development that is already in the area in sections 2 and 11, and then down in section 23, you can see the diagonally oriented from southeast to northwest well in section 23 as well. This is important because these are all also Niobrara wells, and when I refer to any collision risks that we've identified, these are going to be the wells that I'm referring to. And so I just wanted to make sure that we can point that out before we go into any further alternative location. Slide, please. So here is the proposed location. We worked with the surface owner to actually select this spot for the preservation of his ongoing agricultural use. This was his preferential location. It is disturbed, as I mentioned, for agricultural use presently, and there is also additional nearby oil and gas development. Again, no residential buildings, HWUs, or daycares within a mile. It was sited in the center of section 11 to allow for the development of minerals to the north and south, again with consideration to mechanical and collision risks. And it also, from this location, allows us to fully develop sections 2, 11, 14, and 23 from a singular location as safely as possible. It's not inside any disproportionately impacted community, and there are no verified wetlands within the proposed system. The only disadvantage is that it is certainly within mapped pronghorn winter concentration areas. Slide, please. The first alternative location was selected for that reason, proximate to where we're proposing our development at the time that CPW's maps reflected high priority habitat this was the only location that we could identify outside of any high priority habitat. Its advantages are quite similar because it's still in a remote location. And the different advantage for this location would then be that it's outside of any mapped high priority habitat. However, we certainly would not be able to develop all of the minerals in 14 and 23, as this sits roughly 5 miles as the wellbore path would traverse to the southeast corner of section 23. Which then creates a significantly unnecessary mechanical risk for collision and just unfeasibility of developing that second ESU, which would then preclude the opportunity for us to develop all 4 of the sections from a single location. Slide, please. So this is our second alternative location, which would be given thought to the opportunity for location consolidation, as it's a location owned by us. And again, as all the others, it does share the advantage of not being within any disproportionately impacted community or not proximate to any RBUs, daycares, or HOBUs. However, this location also, as the first alternative location, cannot be utilized to develop all 4 of the sections. It would require an additional surface location to avoid waste and unnecessary collision risk. It's already been through its interim reclamation, so it would require additional surface disturbance to conduct all of the drilling and completion operations. And it's, again, closer to an RBU than the proposed location and is still within mapped pronghorn winter concentration areas for high priority habitat. Slide, please. This is the third location, offering, again, because of its remote area, many of the same advantages, not being any disproportionately impacted community or proximate to schools, RBUs, HOBUs, or daycares within a mile. And it's also quite proximate. As you can see, the black line running down near the center of the slide is a county road. However, it's, again, within mapped pronghorn winter concentration high priority habitat and offers the same mechanical risk, which we deem to be unnecessary, developing to the northeast and to the southeast. We would increase our collision risk significantly with the existing Niobrara horizontal wells. Slide, please. This is the fourth and final alternative location that we've considered. This was the location that the CPW had proposed, which is part of its reason for consideration. Offers, again, the same advantages as we've seen in the previous locations. However, the surface owner expressed a pretty strong preference for not utilizing this particular location. It still remains within the high priority habitat area, and as it's only a few hundred yards to the east of location number 3, presents all of the same mechanical and collision risks, which we deem to be unnecessary when the opportunity exists to develop from a safer location. And we feel that this would also prevent us from developing all 4 of the sections from a single location. Would require 2 locations to develop the full mineral area. Next slide, please. So here we are. We've employed these best management practices that are outlined in the next couple of slides to minimize all of our potential impacts. These are fairly standard practices that we plan to employ to mitigate odor and air quality issues. We'll be certainly utilizing a closed loop system. We'll have ECDs to combust any flash gas that might be present in the tanks. During loadout, we'll use a TLVR system to capture and direct odorous air contaminants to a combustor. All the production operations we plan to electrify. The electric provider informed us that the capacity is not available, being Morgan County Electric, for the electrification and drilling of completion operations. We did have an on-site consultation with them with concern for the electrification of the pad, and at that point, we did discuss their deliverability from an infrastructure standpoint for power to run electric drilling and completion equipment. They confirmed that they were not capable of delivering enough power for those options. And then there is existing gas pipeline for takeaway from the first. Light and sound considerations. We will comply with the maximum permissible noise levels as outlined in Weld County Code. The trucks on locations will be prevented from idling. Typical things such as lighting being directed down and inward, and minimizing lighting activity when not needed will be employed. During production operations, there will be no permanent lighting on site, but lighting will be used when personnel are present, but not when they are absent. Next slide, please. The water, land, and site safety is fairly typical as well. We will certainly construct a ditch and berm around the perimeter of the location to control water and runoff. The sediment basins will be east and east of the entrance and halfway up the eastern and western side of the location, and culverts will be like drainage. We've addressed the CPW considerations for wildlife resources, and the most beneficial impact is the development of 4 sections, 2,560 acres, and 11 oil wells from a singular new oil and gas location. There is some but little legacy vertical development, so we expect there should be minimum requirements to plug existing vertical wells, but in 14 and 23 they will be evaluated separately as part of the horizontal offset well evaluation requirement for all the Form 2s. Slide, please. With that, I think that I can hand that back to Ms. Jost.
Yes, thank you so much, Mr. Boyd. I'm just going to provide a short conclusion, and then I'm going to ask Mr. Hinojosa to show himself on video, and we'll address the commissioner comments or questions, I should say. So really just to provide a short conclusion, as you heard today, the proposed pad is sited outside of any human sensitive receptors and only triggered the HPH ALA criteria. Red Hawk did engage in detailed consultation with CPW, and the 5 BMPs listed on the Form 2A were resulting from those consultations. And those Form 2A BMPs do avoid, minimize, and mitigate potential adverse impacts to the wildlife resources in this area. There were no public comments, no petitions, and the Weld County WOGLA was approved. And the director's recommendation did determine that the Roth 2-11 OGDP complies with the commission's rules and recommended approval. So with that, we would request approval of this OGDP application. And I would like to go ahead and bring Mr. Hinojosa up. Ms. Gross, you can stop sharing the screen if that works for you so we can see everyone. And we will go ahead and address the 4 commissioner questions that we received. Excellent. Thank you. Good morning, Mr. Hinojosa.
Thank you, Ms. Jost.
Yeah, I'm just going to start with question 1. Can you discuss the status of the oil and produced water takeaway?
Yes, we have, for this application purposes, we are permitting the oil and water takeaway to be trucked and the gas to be piped off. However, we are in detailed discussions with third-party company called Taproot that has midstream infrastructure in this OGDP area. The tie-in point is about 2.5 miles from the proposed drilling location, and negotiations are ongoing to attempt to come to an agreement to be able to utilize that pipeline, but we have not reached a final agreement yet.
Great, thank you. And with respect to question 2, what kinds of equipment, engines will be used for drilling and completions on this pad?
For drilling operations, we will be using Tier 2 engines. This is what's available, and due to being as remote as we are, over 2,000 feet from any human receptors, we do find this to be acceptable. For completions engines, we are in communication with frac companies. being that we're a little bit far out from our frac date still, we don't have a verified assigned frac fleet at this time, so we can't say specifically what type of engine it will be, but we are having those ongoing communications and do expect to be able to have Tier 4 engines. We just don't know what specific variety of engine yet. Until we get approval here and get closer to our frac date, we'll get an actual frac fleet.
Great, thank you. And then the third question was, is the pad going to be electrified?
Yes, the pad will be electrified for production operations.
Great. And then the fourth question was, can the operator please run through their air emissions estimates in the Form 2B?
Yes. So there's a couple of high-level answers to why there were some zeros in there, which were identified. The first component being that for the gas components, we used a sample from the area, but for the liquid components, we did not have a representative liquid analysis for this particular location. So we used the state default emission factor, which does not contain the full spread of some of the components. And then there were also a couple of instances where there were some smaller values that were stretched out to multiple decimal places that didn't show up when rounding to only one significant figure on the Form 2.
Great, thank you. So Chair, that would wrap up our responses to the commissioner questions, recognizing there likely will be more. We are ready to bring the rest of the panel on, if that would be okay with you.
That sounds good. Thank you for the proactive answering of questions. Commissioners, the panel is available for further questions. Commissioner McGowan.
Thank you, Mr. Chair, and thanks for being here today and sharing some information. So the question about the emissions in your Form 2B and trying to figure out how you came up with those values was from me. And I'm going to preface my comment by I am not an air quality expert, but I'm used to seeing from some applications that are a little more detailed about the equipment that they're going to provide and how they're going to do pre-production activities, where there are some emissions values for things like the wellhead and unloading, and you all have a significant number of zeros, and you're also going to use a Tier 2 drilling engine, and you're not sure what you're going to use for completions. So I'm wondering, what equipment were you assuming that you were going to use when you came up with your 2B estimates? Were you assuming Tier 2 engine and a Tier 4 completions?
We were assuming Tier 2 engines for the drilling portions, and for completions, we were assuming diesels.
Sorry, you were assuming also for
diesel engines for completions as well.
Okay, I think I'm just a little stuck on again, I'm not the air quality expert, but I'm not quite sure. I believe your Form 2B as emissions estimates. So I don't know what to do about that. And there's really, I mean, I have to trust you on your word about it. But you're using some more polluting engines than we typically see in some of our more recent applications, where there are emissions estimates in those columns for HAPs and for air quality criteria pollutants. So I'm just trying to figure out how this is working out. And I'm just letting you know what I'm kind of struggling with.
So Commissioner McGowan, if I could step in, we did have a discussion with our air quality consultants immediately previous to this to sort of try to address some of these concerns. And one of the things that we did discuss was when timing is nearing, we'll have much more clarity as to what's going to happen, and we would be happy to make sure that we update all the 2B numbers when we have more information regarding how all of the drilling will actually be executed.
Commissioner Messner.
Thank you, Mr. Chair. I want to follow up on Commissioner McGowan's questioning there. You know, as I evaluated it, that Form 2B needs to be filled out with the equipment that you're anticipating and using at the time that you're filling it out. And I'm hearing that Tier 2 diesel engines are anticipated to be utilized. Oil is intended to be trucked. Group 1 drilling mud is intended to be used. And understanding that, it appears to me that those numbers are wildly inaccurate. And so I have a heartburn with that, and I think that needs to be addressed in this particular application. And so I just want to state that initially. I do want to confirm with you that, you know, while you're trying to do things, currently what you're proposing and what we'll be making our decision on is Tier 2 diesel engines for drilling and completions, Group 1 drilling muds, and oil and water to be trucked. And I'm not seeing any information contemplated in the application on the potential impacts associated with trucking oil. I'm not seeing any truck trips in your transportation plan being contemplated for trucking of oil. I'm not seeing anything in the cumulative impacts analysis associated with trucking oil. Am I missing something, or is that not being contemplated in your application?
I believe that we have included the trucking and transportation in the application.
And so I've reviewed your transportation plan and I've reviewed your cumulative impacts report. Maybe you can point it out to me, but I'm missing it.
Thank you, Commissioner. Oh, I was going to say, can we pull or turn this over to Ms. Gross?
Yes, Commissioner Messner, thank you for that question. Truck traffic are included in the transportation plan unless
for produced water.
Oh,
but
for
it's not for oil.
They were not broken out, so now I understand.
Well, it says in the transportation plan just produced water, so it doesn't even indicate that oil is going to be contemplated in that.
We would be happy to look at the numbers and update them. We can definitely do that. I think that was probably not clear. These traffic numbers that we submitted were for both water and oil, because it was always assumed that oil would be trucked off.
And the numbers for the oil inside of the cumulative impacts analysis in the Form 2B, I'm not seeing any line item in there for transportation or trucking at all, unless I'm missing something.
No, I believe you're correct. I don't believe that we called out specific numbers during the cumulative impacts plan, but I will take note of that and we can include that.
And so again, just to confirm, Group 1 drilling fluid, Tier 2 diesel engines, completion and drilling, you know, a number of oil tanks on location, oil being trucked away, water being trucked away. I mean, in fact, since I've sat here, I'm not sure I've reviewed an application with this type of technology being proposed, particularly in the non-attainment area. I'm wondering if it was communicated to CDPHE that this was the technology that was being proposed when there was a request for consultation.
There's a couple of items here. As far as the drilling fluid goes, the Group 1 drilling fluid that we're proposing is Gibson D822. It does act as a Group 2. It's technically classified as Group 1, but it does act as a Group. And its emission profiles are are similar and reflect that. And as far as the trucking of the oil goes, we do have included in our calculations that all of the trucks would be emissions on site would be tied into and routed through our control devices within the facility.
You're talking about storage tanks.
Yes, the truck loadout emissions would be routed through the storage tanks and into our control devices.
So one of the questions that I had though was the CDPHE, were they informed of the technologies that you were proposing when they were asked to consult on this, or was they asked to consult simply because there was were provided information only on proximity to disproportionately impacted communities and within 2,000 feet of RBUs?
Mr. Mesner, I'll take that question. We reached out to CDPHE and requested consultation because the location is in non-attainment. That is what triggered that consultation request. At the time, CDPHE had information regarding the location that was provided within the permit. They declined the consultation because of the fact that it is in a very remote area and greater than 2,000 feet. I'd also like to say that they still had opportunities to comment on the permit. They had, in my understanding, they have access to all the plans, but it was not called out specifically to CDPHE that this was the technology that Red Hawk would be proposing. That wasn't specified in our request for CDPHE consultation, but CDPHE declined the consultation, as well as they did not provide any additional comments on the permit during their review.
Okay. Thank you for that. I wonder if you could talk a little bit about the engineering testimony and ECMC staff consideration that the DSUs would not be fully drained with the plans that you're contemplating here. In fact, I think that they're contemplating about their calculations were some 370 acres would actually be drained out of one of the 1,240 acre DSUs. And so maybe you could talk the engineering behind that and how you feel like you're addressing correlative rights in your engineering plan.
Yeah, and Commissioner Messner, I'm happy to take some of that. And then if Mr. Ken Cooper could come on video, or Mr. Clutho from Petrotech. So Commissioner Messner, from the engineering perspective, we recognize that it did state that it may be underdeveloped, the DSU. And actually, technically, I think it'd be the DSU to the south, section 14 and 23, because the 2 and 11 already does have development. We're adding additional wells that are in there. There is always the ability, before I turn it over to Ken or Mr. Clutho for the actual drainage piece, from the correlative rights perspective, all mineral interest owners within each unit will be paid on the unit basis. So they will get their proportionate share from all of the development in the area. We did not have any comments or even outreach from mineral interest owners, and they did all receive notice of this application. Secondarily, if there would be additional wells that would be needed for additional drainage of the units, Red Hawk has the ability to come in and ask for increased density. That would amend the OGDP, and we'd be right back in front of you asking for those additional wells. But at this point in time, that's what they are proposing with respect to the number of wells in this 1280 with the 6. And again, I'm focusing on the southern DSU, that 14 and 23 with 6 wells, recognizing there's always the ability to come back and ask for more if needed.
And when you say ask for more, you're talking about a second sighting and a second drilling, or making an amendment prior to the first occupation, because we're talking about high priority habitat here, and multiple occupations and high priority habitat is potentially problematic, right?
Right. And that's why they're looking to come in with this one occupation. All I'm saying is that there's nothing in the rules to prevent them from coming back and saying, maybe we need more wells at this point in time, or sorry, in the future. But right now they're seeking the wells in order to have a single occupation, to drill north and south for the additional 11 wells to have that development. On the basis of just, again, kind of going back to our statute with respect to the spacing unit, the spacing unit does have one well. So what we're asking for is the spacing unit to be developing one or more wells. And under the statute, we've had the ability to show that to protect correlative rights and to prevent waste, one well will drain less than 1280. We're just asking for 5 additional wells in that southern portion in line with the statute. So that's kind of the perspective of, you know, from the legal standpoint. Mr. Cooper, I'd like to go ahead and turn it over to you for purposes of the well count and the drainage, recognizing Commissioner Messner's question.
Sure. Thank you, Commissioners. To address this, that there's, I think, 2 facets here. First is from a correlative rights perspective. And as Ms. Jost had indicated, the intent here is that mineral owners would receive their proportional shares. Further, there is not a concern with respect to draining more resource than is present within the DSUs that are proposed. Excuse me. From the perspective of the potential for waste or the potential for not being able to produce certain hydrocarbon from the DSUs, from the OGTP, I think the concern that was expressed in the prior testimony is consistent with our understanding and our previous discussions with Red Hawk, in that incremental risk of significance is present with regard to drilling further and drilling larger distances and having concern about potential for collision factors. So I think part of what ends up happening with some of the issues is that we run into the potential for not having horizontal well bores that extend to the full length that would be necessary to drain kind of all the way out to the toe, if you want to look at it that way. And so to minimize those risks in a way that Red Hawk finds acceptable, this location and this number of wells is proposed at the outset. As Ms. Jost had indicated, if there is concern or if there is economic incentive to increase the well count at some point in the future, obviously that would have to be something that would be asked for by Red Hawk as a kind of a second go, if you will, from that pad.
Okay. So I think what I'm hearing you say is you acknowledge that potentially you would not be draining the full extent of the DSU, which, I mean, I don't have a problem with that. Where I'm struggling is that a lot of your arguments in your alternative location analysis as why you cannot use certain sites is because you wouldn't fully drain the drilling and spacing unit.
Yeah, I think
so this is where I'm struggling, is there's perhaps sites that better avoid impacts that wouldn't fully drain the DSU, but you're choosing not to have it there, even though the one that you're choosing, you're acknowledging that doesn't fully drain the DSU.
Yeah, I'd like to provide some additional detail, if that would be acceptable.
Absolutely.
So yes, there is the potential for additional hydrocarbon, as had been indicated in the testimony. Our drainage volume does not 100% drain the DSUs, but incrementally, there is a much larger risk of not draining substantially more and having the ability to then subsequently drill more wells would be potentially compromised because of the way that the initial drainage was accomplished. So I'll give you an example. If we were unable to get a well that had a toe out to its design length, the drainage beyond that toe, kind of in that stick, in that pattern, would be something that we would not be able to go back in and accomplish. If we were to have the spacing that is currently proposed, and in the event that decisions were made that it was economic to increase density and drill between. So if we were to amplify the pattern and have additional incremental well sticks within that pattern, drilling between the existing wells might be something that could be accomplished. But if we had 500 feet or 1,000 feet off the end of a toe, pretty much we would be stranding that resource out at the end. If that makes any sense. I don't really have a graphic to show you here, but
I understand what you're saying, and so this is why I'm digging into this a little bit. But what I think what I'm hearing you say too is that there's a pretty good chance that there would be a second occupation in order to be able to fully drain the DSU and develop if the economic conditions were correct. Is that what I'm hearing?
Yeah, I think the intent here would be to optimize stimulation that are applied, and that given sufficient time, we would have drainage that would be acceptable. But in the event that that does not end up draining as much as would be liked, yes, there is the possibility of a second drilling mobilization.
Yeah, and Commissioner Messner, if I could jump in too, we are not proposing a second occupation here. We are just saying that, and Mr. Boyd and Ms. Gross, I'll get to you as well, but I just want to be very clear on the record. We're not proposing a second occupation. This is all focused on a single occupation on the pad that's being proposed to you under the rules that we are required to follow. We are also very concerned about collision risks. And so, Mr. Boyd, I'd like you to come and go ahead and explain to Commissioner Messner, again, some of the reasons about the alternative location concerns and how those pose mechanical risks versus the drainage concerns that we've just been addressing.
Thank you, Ms. Joseph. Commissioner Messer, to address your question. During my testimony, I believe that the most significant concern that I stated for each of the alternative locations was collision. Because of the existing development in the Niobrara and the horizontal development that's in these four sections, as you move farther and farther away from those wells and drill toward them, your control greatly decreases. Coming from a landman, remember. So our greatest concern over drainage was most certainly the mechanical risk and avoiding collision. So our main mindset was for safety in these situations and trying to accomplish as much drainage as possible from any of the locations while minimizing risk of collision with any of the existing wells.
Yeah, I understand that from your presentation. I think that your alternative location analysis summary inside the application did indicate things other than collision as being considerations in some of those. And so that's where I was reading that information is in the application itself. The other question I have, just so that I fully understand, is well, a couple of different things. So there's a timing stip that you're proposing. That was a request from CPW, and I understand that. There's also compensatory mitigation that's being contemplated in this particular application. There's a couple of different classifications of compensatory mitigation, whether you're choosing to leave the option open to drill inside of the timing stipulation or not. But I think what I'm hearing you say, at least, is that you're committing to not doing construction, drilling or completion activities during the timing stipulations, and you'll pay the associated compensatory mitigation with that decision. Is that correct?
Yes, Commissioner Messner, that is correct.
Okay, and that does include direct and indirect compensatory mitigation as lined out in Mr. Moret's email chain that was provided in the application.
It does, yes.
Yeah. And then, but no timing steps considered. I mean, let me ask this. So you talk about, and I'm not going to get the term right now, but a natural drawdown of production during certain times of the year where there may be that may be more sensitive to wildlife in order to minimize the truck traffic associated with this particular location. but I don't know what that means exactly, and I don't know how much it minimizes truck traffic. And so I wonder if we could actually get like anticipated numbers, months that you can draw it down. Just talk a little more about that.
Yeah, so especially with the initial production surge, especially on the produced water side, you see a much higher initial production for the first 2 to 3 months or so, and then from there it markedly reduces the amount of produced fluid production. So based off of that, we would see significantly decreased truck traffic in the area by the time that we are back into the winter habitats.
So you're just talking about the bell curve. I thought that you were proposing some sort of, artificial suppression of production during certain seasons, but you're just talking about the natural bell curve. Is that right?
Yes, sir. The natural decline, sir.
Okay.
With that, Commissioner Mesner, one of the conversations we had with Brandon was if able to keep this timeline, that bell curve would also coincide with the timing stipulations for the next year. And Red Hawk also discussed being able to consolidate some inspections that would take place during the winter months. They're going to try to consolidate that as much as possible to also reduce truck traffic and impacts to the location during the sensitive winter months for the pronghorn.
And so I better understand the access road. How far is the access road from the county road in this preferred alternative site?
It's about a half mile.
Okay.
It's an existing 2-track road that will need to be upgraded. There is already access into that parcel that we're utilizing, but it will need to be upgraded for oil and gas operations.
Mr. Chair, those are the questions I have right now. Thank you.
All right, thank you. Commissioner Cross.
Thank you, Mr. Chair. I just want to try and get some clarification. You indicated that you would have a better idea, excuse me, with respect to type of engine being used, have a better idea of being able to do oil takeaway as you get closer to production. How long do you anticipate knowing before you would have a more definitive answer on those issues?
If I may, as far as the completion goes, quite frankly, one of the main hurdles that we're facing with locking down an official frac date is having our OGDP approved, especially since we're a relatively new operator to completing wells in this area. We don't have an established designated frac fleet that we're designated for using these months out of the year. So it's going to be a kind of spot work where they can fit us into their other schedule, other operators. With that being said, it's difficult to put an exact timeline on it, but I can tell you that I've been having regular check-ins with the completion companies, and that's the feedback that we're getting is as soon as we've got this approved, we can we're tentatively penciled in for a date, we can start putting that into once we're.
And what about with respect to drilling?
For drilling, the drilling using tier 2 engines for drilling is really just based on the availability on the surface side. It's my understanding that there just really aren't any higher tier options.
But have you inquired with respect to beyond tier 2? I don't know if you listened to the previous applicant, but sorry, 2 previous applicants, but looking at natural gas tier 2 engines or using a battery assist or other mechanisms that can help it. And I'll give you an idea of where I'm going with part of this is I can appreciate a lot of the steps that you have taken to ensure there's one occupation, steps that you've taken working with CPW to make sure you're adhering to their timing limitations. But at the same time as you're adhering to the timing limitations that CPW has, it also would put potential drilling and completions right in the middle of ozone season in a non-attainment area. And I know that that's one of the common themes we're getting as we listen to a lot of discussions about cumulative impacts, et cetera, is, you know, how can we reduce ozone considerations, especially during ozone season in the non-attainment area. And to follow up on what Commissioner Messner said, I know that that's one of the things that I do have some hesitancy with here. I do like the fact that you're away from RBUs. I do like the fact that you're working well with CPW and you're taking a lot of these steps to make sure you're doing things the right way, but just kind of having that open-ended, well, for right now, we can use tier 2 rigs, group 1 mud. You talked about it being sort of like group 2, but group 1 mud, when group 3 mud would be better as well. And not sure on the completions either. So it's a lot of these emission factors that, because of the timing steps with CPW, then put a lot more pressure on the ozone season. And so that I'm just kind of wondering if there's a way of saying, given more time, would you be able to say, yes, we can get tier 2 drilling, but with a battery assist. With more time, we could be able to make sure that we can do a tier 4 completion engine. Given more time, we could lock up what you're trying to do with the oil takeaway to avoid some of those truck trips, some of that. And I'm just wondering if more time would help with that, or if this is kind of what you can do at this point.
So a couple of points here. One, we have inquired with the drilling companies about alternatives and higher tiered rigs in the area. For number 2, the completion fleet will be tier 4. We just can't specify if it's going to be dual fuel or natural gas. That's the kind of detail that we don't have. And I guess the final verdict on how quickly we can be able to obtain this is it's very difficult to put a exact time commitment on there. I would think that we could certainly provide the additional information and information in an amendment or updated Form 2B cumulative impact program once we do have all those final pieces of information to plug in.
And we would certainly do so as soon as practical. I mean, we're more than happy to commit to updating all that information as soon as we have the availability of equipment and crews for all of the different aspects of these operations.
And I guess just to clarify a little bit, you did talk about ongoing discussions with the midstream company can you provide, and obviously I know you can't talk about all contract negotiations, et cetera, but can you provide a little bit of detail of like, is it pretty close? Does it seem like there's still a lot of talking points left? Like, do we have an idea on that?
Yeah, I would say, I am optimistic that we can get there. I think that it could be close, but I guess you could say that the overall structure is somewhat in place, but we still need to work out the contract.
I'm sorry, I didn't know, Ms. Jost, you were getting ready to say something.
No, that's okay, Commissioner Cross. One thing I just wanted to add, and Mr. Boyd just said it too, not only just providing those numbers, but Red Hawk would be okay with a condition of approval on this OGDP to provide those updated emission numbers prior to drilling and completions. And so that has been done previously by this commission. You guys have requested that, and we would be willing to do that here as well. Because as Mr. Hinojosa said, some answers we might need depends upon the approval of this OGDP. And that's really what we're looking for. So thank you for allowing me to jump in.
Thank you. That's the only questions I have right now.
Commissioner McGowan?
Thank you, Mr. Chair. I guess I was curious to know if there was any exploration into a tier 2 that's been, kitted out. I guess I'll call it kitted out, right? So using dual fuel or battery assist, which, while still not favored by the commission, is a lower emissions profile than just a regular tier 2 diesel engine. And so I think you're feeling some pushback from some of the commissioners because it is rare and few and far between we're seeing a tier 2 diesel for drilling in the non-attainment area, which leads me to believe that we have equipment available to operators that's better than what you all are proposing. And in all honesty too, this is a hard one for me to run through the first time around because you were not clear in your application what it was that you were doing for drilling and completions, which almost all the other operators supply to us ahead of time. So then when I'm reviewing the 2B, I have no idea what I'm working off of. This just it felt very incomplete when I was trying to review your application. And it doesn't feel like it's, quite honestly, as protective and as on par as the other applications that we've seen from other operators, small and large. And so I am a little frustrated.
Yeah, Commissioner McGowan, we have the ability to bring Mr. Johnny Musso up to talk about the drilling equipment that's available to your question there. Mr. Musso, if you may.
Thank you. Good morning, everyone. I appreciate your guys' time. To speak to the drilling equipment available, right now about half the rigs in the basin are running on either some form of highline power or a dual fuel combination. To my knowledge, there's only one rig in the DJ with a tier 4 engine on it, and that rig is under long-term contract. I have heard discussions about other rigs being fitted with tier 4 engines, but that, to my knowledge, has not occurred to this point. A lot of the uncertainty you're seeing here is mainly due to what we've already said. It's based off of rig availability and what's available during that window that we are given. So we can make efforts and do everything we can to try and ensure that we are meeting these reductions and achieving the emission reductions everyone would like to see. But until we have that actual window, we're unable to actually specify which rig. And a lot of that has to do with most of those rigs that are on some form of highline power or dual fuel are on long-term contracts. So being able to have that timing and then being able to see what rigs are available in that window is part of the uncertainty that we have going forward.
I also see that you all are proposing to start drilling in May, which is the beginning of our ozone season. Are you tied into that timing? Can we try to drill outside of the ozone season if you're using this kind of equipment? I'm trying to figure out how we can manage that with also not running into the timing stipulation for pronghorn.
Well, Commissioner McGowan, I don't want to speak for Red Hawk here, but I think that's part of the balance that we're working with. I do think, as Mr. Musso has said, the small or large operator, the tier 2 is the rig that's available during the timing steps that Red Hawk has worked very significantly with CPW. And so again, this is that balancing factor that I think all of us have had to kind of work through and take into account here. When we look at this from the portion of the ozone season, we do recognize where things sit in the state of Colorado with ozone. But, I will turn to Mr. Boyd for purposes of your timing limitations and whether it has to occur during ozone season. But, Red Hawk has taken a lot of steps here with respect to CPW, with respect to locating this outside of 2,000 feet, outside of a DIC. We're not in a cumulatively impacted community, and there's a lot of other steps that should go into consideration when we are looking at this, along with air emissions. And so I just kind of wanted to say we understand the balance that you as the commissioners have to work through on this, but there are a lot of other benefits associated with this location, in addition to potential air emission reductions that would come into play. So Mr. Boyd, not to put you on the spot, but Commissioner McGowan's question was to consider any development outside of the ozone season. And I don't know what your thoughts are on that.
Thank you, Ms. Joseph. Thank you, Commissioner McGowan, for the question. One of the things that we're up against is honestly just that we're small. These are the first wells that we are going to drill in Colorado. We don't have, although we do have relationships with vendors, we don't carry a lot of water. It's something that we plan to continue developing in Colorado. We think it's a good part of our asset profile, and we're excited to get into this particular opportunity. So as far as taking consideration for the least emissions that we can produce and the best quality drilling equipment and completions equipment that we can get to minimize impacts during the ozone window, it's something that we're certainly very focused on, and we do what we can to try to find the equipment that does produce the least amount of emissions, but there's the overlap of the consideration of the ozone window and the wildlife windows. And unfortunately, those two things sort of run consecutively rather than concurrently. So we will do what we can, but at the same time, it's just that we have to work within the constraints of what we're capable of as such a small company.
Further questions? Commissioner Ackerman?
Thanks, Mr. Chair. I'll be brief here as my notes are very similar to the questions that have been asked. I wanted to also reiterate that I appreciate your work with CPW. I'm generally okay with the results of that work. I do have considerable concerns over the emissions profile. Like I said, my questions on that front have been asked and answered, and I'm happy to talk more about that in deliberations. I did want to touch just on one point of interest to me, and not necessarily because I think it should change your application entirely, but this is the first that I've heard about considerable collision risk controlling the placement of a well. And while we have talked with other operators about, that we do have to be careful about collisions. Generally, the answer that I've received is that these wells are heavily mapped, technology is precise, and we're able to work around, even very complex fields that have significant downholes in them. And so can you elaborate a little bit on why collision risk is it has such a high profile in this application and is driving your potential for location of the site?
I think there's a couple of factors within that. One of the issues with some of about half of the sites is that you've got half of the alternative location sites is you've got multiple laterals within one same area right off the bat, not just crossing right there at surface, but also the existing laterals are somewhat unfortunately, they're landed in a good place that is basically the exact same lateral target bench that we would be going after with these new wells. And with that being said, there's not as much additional data points in this particular area for extended reach drilling as there may be more towards the core Wattenberg area.
If I could jump in also, and I know the collision risk is something that we continually mention when considering the alternative locations. However, the location that we've chosen also is the only location really where we think we could develop all 11 of the wells from a single pad. It was really not just necessarily that there's increased risk that we were unwilling to take on, it's that we wanted to minimize the surface impact as much as possible.
Thank you, Mr. Hinojosa and Mr. Boyd. I would agree. I certainly prefer one pad as opposed to two when you're able to do that. So thanks for that further clarification. Mr. Chair, that's it. Thanks.
All right. At the risk of us having exhausted questions, I believe I need to call for a lunch break before we move into deliberations. At least one commissioner has some matters that need to be taken care of over the next hour. So if everybody is comfortable with that, I would move that we take a break until 1:45 and then come back, and at that time we can initiate deliberations. Okay, we are back. It remains to be December 13th. It is 1:45, and we are going to retake up docket 2305-00185, the Red Hawk Petroleum LLC OGDP. We had set this up to give a lunch break. We now are back. I think, had finished up questions. I did want to potentially recognize Ms. Jost if she had anything further before we move into deliberations.
Yes, thank you, Chair. And if I may, Ms. Amaro, would you mind promoting Ken Cooper back to the panel? I think he's the only one that may have dropped off during break. Thank you. And Chair, we don't need to wait for him, but thank you. I had a chance to have a few conversations with the Red Hawk team over the break, so I hope you guys had a good lunch, and thanks for the time to collaborate on that too. But I just have a few points I'd like to just go ahead and really just to put on the record as you guys start your deliberations. The first one is that Red Hawk has proposed a condition of approval to update the 2B prior to drilling and completions on the Roth 2-11 pad, and would request that the allowance of the COA be applied in this circumstance, similar to what the commissioners have approved on prior approved OGDPs. The second point is that Red Hawk has presented one multi-well pad that is fully compliant with our current commission rules, and this compliance has been confirmed by the director and the director's recommendation for approval. The third point is that Red Hawk has an approved WOGLA through Weld County, which is a vested right, and Weld County did address the truck traffic associated with the location and approve the plan. The fourth point is that Red Hawk has worked extensively with CPW to develop a detailed plan of development that protects wildlife resources and confirm that they will not drill in the winter season. The fifth point being that Red Hawk did request consultation with CDPHE because this location is in a non-attainment area, and CDPHE, with the knowledge and full access to the Form 2A, 2B, and 2C, declined consultation and did not place any additional BMPs on the OGDP or this location. The sixth point is that Red Hawk has met all of the statutory requirements under 3460-116 for the establishment of DSU number 2, and has provided substantial evidence and testimony to support that correlative rights are protected and that waste will be prevented. The seventh point is that Red Hawk has provided substantial evidence and testimony at this hearing, as well as through its filing, of compliance with the current commission rules, and has also stated that it has and will continue to conduct communications with Taproot as well as the drilling companies prior to joining completions. And although oil and gas pipeline takeaway and confirmed engine type requirements are not part of the current commission rules, these communications and avenues will continue to be open for communication, and Red Hawk will provide any updates on that on an updated 2B. And then finally, Red Hawk is looking forward to developing this first OGDP in Colorado and recognizes the desires of Commissioner Messner and Commissioner McGowan. When balancing the air emissions aspects of development, along with all of the other beneficial aspects of Red Hawk's proposed OGDP, Red Hawk maintains that its proposed OGDP is protective of public health, safety, welfare, environment, and wildlife resources as required by the Oil and Gas Conservation Act and as stated in the director's recommendation. So Chair, thank you. That's all we have. We appreciate you allowing me time to put those points on the record. Very good. Thank you for that recap. All
All right, commissioners, I think it's up to us now to deliberate. I want to put Commissioner McGowan on the spot. You had raised some, I thought, legitimate concerns about the Form 2B and it not necessarily being finished or fully developed or something along those lines. And I'm wondering if we're in a spot today to be able to fully consider this, given some of the missing points within the application. And you had raised that to begin with. So I just wanted to start a dialogue along those lines with some of the points you'd raised, because I thought you had some good points there.
Thank you, Mr. Chair. I've been trying to figure out, there are some things to appreciate about this application. I'm actually at a point where when I was reading the application, I was concerned that perhaps it actually wasn't actually complete because there was information that was missing that didn't really give me an opportunity to figure out if things were accurate. And so I couldn't tell from your application what you were using for drilling or completions. And I realized we don't have rules that require any type of engines, but in order to assess the 2B, it is helpful to know what your setup's going to be so that we know what the emissions looks like for pre-production and production. And that's required in the Form 2B. So I actually think this application is incomplete, and I would love to see the operator go back and sharpen their pencils. And I would like to have them reassess the information they put in the 2B, because I personally feel like if you took another look and saw what other operators have put together for their Form 2Bs, you might want to take another look at your assumptions around emissions. And the Form 2B should be based on what you're willing to commit to, able to commit to for drilling and completions, because that's what your 2B is going to be based on. And that's where I am at right now.
Thank you for that. I think I'm kind of in a similar spot. Do other commissioners have initial deliberative thoughts or ideas about this particular issue? Commissioner Messner, then Commissioner Ackerman, then Commissioner Cross.
Thank you, Mr. Chair, and thank you for kind of teeing off the conversation, because I'm of the opinion that the application is not ripe for review and is incomplete, and I don't have enough information provided to me in the application to make a determination of whether this ultimately meets our rules and is protective of public health, safety, welfare, the environment, and wildlife resources. I think there's inaccurate information in the 2B. I think there's lack of clarity as to what they're actually committing to that would enable BMPs to be developed around technologies that are being contemplated here. I do think that there's some additional information that needs to be provided as to why oil takeaway is not reasonably accessible. It doesn't appear to me, or it appears to me that it's reasonable and certainly necessary as to consider oil takeaway in this situation, and when it's being sited inside high priority habitat and the trucking being contemplated, certainly will occur during the high priority habitat winter concentration season. I know, because I called CDPHE, that they were not aware of the technology that was being proposed here. And I'm not sure they could be aware, because the application was so vague as to what was being proposed for technology. And that if they knew that the technology that was being proposed now was being proposed, that they would have preferred to consult on this in the non-attainment area. So it would also ask for a CDPHE consultation in this particular situation, which in the end, I think has the potential of benefiting the operator in their compilation of a fully complete application. So I guess the short of it is that I would agree. I think a continuance is appropriate. And there are things that could be improved and contemplated within this application to make it complete so that I can make a determination on whether to recommend approval or denial of this application.
Commissioner Ackerman.
Thank you, Mr. Chair. Like others, I do think there are redemptive qualities in this application. I appreciate this operator's coordination with CPW that resulted in proposed drilling and completions outside of pronghorn winter timing stipulations in pronghorn HPH. Also resulted in compensatory mitigation to a total of $89,127. I do recognize that CPW doesn't prefer locations in the middle of sections, but rather prefers them near roads in these types of rural environments. But as was pointed out by the operator, that would necessitate 2 pads, and a single location farther from the road is generally preferable to multiple locations. All in all, I find the consultation with CPW to be approvable and adequate. From an engineering perspective, I appreciate the discussion regarding spacing and the number of proposed wells, including the development's potential to not efficiently extract oil and gas from the field. And I do note that the act was amended so that such an approach is no longer considered waste. I would have a concern about a second occupation being found to be necessary and proposed within HPH due to an avoidable inadequate approach during the first occupation. That would cause me concern. I also note that the staff engineering review of the spacing application and engineering testimony was clear to indicate that the application was not acceptable overall, but that it meets the minimal requirements of ECMC rules in the Act. And then I think where things really go awry for me is with regard to air pollution. Beyond being incomplete, I have concerns that this application isn't compliant with the standards set forth under the Oil and Gas Act. As has been pointed out multiple times, it proposes Group 1 fluids, Tier 2 engines for both drilling and completions, trucking of oil and produced water. And in my view, while our regulations do allow for the use of each of these technologies in order to provide operator flexibility in situations which, despite an operator's best efforts, a certain type of engine may simply not be available, or pipeline infrastructure doesn't exist, therefore it's not mandated, or it would be more environmentally costly to construct than the impacts of trucking over the anticipated number of pads in the area, or should Group 2 or 3 MUDs not be necessary or be unavailable, etc. But to see an application that selects technologies that across the board, for lack of a better term, are scraping the bottom of the emissions technology barrel, when pipelines are available and could potentially be connected, and cleaner drilling fluids could be used, and cleaner engines technologies are routinely able to be acquired and or committed to by other operators, and to propose it all while operations are within the ozone non-attainment area makes this application particularly problematic to me. So our regulations implement the Oil and Gas Act as amended, and therefore ostensibly, if an application is compliant with our regulations, even at their lowest common denominator, one could argue that it's compliant with the Act. I find that this application is one of the few that may meet the standards set forth in regulation minimally, but given the totality of operator choices versus availability of polluting technologies when lower emission options are feasible, given that those choices are all being made in the non-attainment area, I find that this application is not reasonably compliant with protecting public health, safety, and welfare, specifically due to avoidable, inadequate proposed air quality protection. As I think many of the most egregious issues with this application are addressable, as has been pointed out, and address issues that are, in my opinion, reasonable and necessary to be in compliance with the Act, i.e. improved air quality in the non-attainment area, my preference would be to provide the operator with more time, as Commissioner Cross proposed, to work through some of the issues that it would at least allow them to, at the very minimum, properly explore and state what equipment they plan to use, and to complete ongoing pipeline negotiations in a way that definitively allows them to state whether midstream transport will be available to them, and in a way that allows them to contemplate and propose reduced trucking, in a way that allows them to properly complete their emissions forms, and in a way that allows them to contemplate and consider better fluids, I think is prudent should they feel that they have an opportunity to improve in those areas. Otherwise, in its current form, it really is difficult for me to support this application as one that meets the standards of the Act. Thanks, Mr. Chair.
Commissioner Cross.
Thank you, Mr. Chair. I'll try to be brief, especially because it sounds like the majority of my colleagues are all in favor of continuing this and letting the operator provide some more information, and I think that's appropriate. I will note it, as Commissioner Ackerman said, what's being proposed does meet our regulations, and so I think then the next step is it adequately protective of public health, welfare, environment, and wildlife resources? And at this point in time, I think the question is, I'm not sure. And part of the reason I'm not sure is, we don't have CDPHE's input here, which I think is important. Recognizing the discussion back and forth on whether there was consultation requested and denied, and the information that may have been known. But I think stepping aside from that, I think one of the things that sticks out to me is that, as I noted in my questioning, the operator has done a good job of taking the time to work with CPW to make sure, hey, we're in high priority habitat. What can we do? Let's work on timing limitations. Let's work on mitigation. Let's work on making sure that this is up to snuff with respect to what Colorado Parks and Wildlife thinks is appropriate. But given that it's in ozone non-attainment, and given that there's, again, as Commissioner Ackerman said, kind of the bare minimum to meet our regulations, it does raise questions. And one of the key points to me that came out during the discussion and presentation today is the fact that there may be better opportunities out there. They're trying to get an oil pipeline. They're not sure if they'll be able to finalize the contract. That's a maybe. That could greatly improve things, reduce a lot of truck traffic, improve emissions a lot. And it would also benefit the wildlife, I think. And then you also look at the fact that they said there has been some discussion with drilling operators that for alternatives. So going beyond, yes, there may not be a tier 4 engine available, but could there be a battery assist? Could there be dual fuel? Could there be a natural gas rig? Could there be something else out there? And what I heard in testimony was we had some discussions with that, but I didn't hear anything concrete saying it's not available. We cannot get it. That's why we're stuck with tier 2. We've talked about it. It's again, another maybe. And given the increased concerns with air emissions, I do think it's appropriate to give the operator time to determine whether these things can be done. Because I think the more steps that they can do to make sure that they're minimizing emissions to the extent possible in an ozone non-attainment area, I think that's going to only benefit public health, welfare, environment, and wildlife resources. So while I agree with Commissioner Ackerman, I do think that this meets our regulations. I do think that it's appropriate to give the operator additional time to see what else can be done, and really, as Commissioner Messner said, really nail down what is this application requesting. Are they ultimately sticking to a tier 2 rig flat? Are they sticking to trucking? Are they sticking to group 1 mud? What ultimately is going to be what they're proposing here? And I agree that we could have the form to be updated once this is done, but I think this provides them an opportunity to come back and say, here's our cleaned up application. Here's everything that we 100% can commit to. Here's what we think the estimates will be under the 2B, and this is what we're putting forward as our final proposal. And so I agree with my colleagues that I think this is probably best continued until we can get more information. You're on mute, Mr. Chair.
Sorry. Okay, appears there's consensus that we should continue this matter. Would appreciate Ms. Jost visualizing herself.
Chair, can you hear me?
I can hear you, yes.
Okay, my apologies. I'm getting a message when I try to, never mind. I think the video had been stopped from your side, so I had to rejoin.
Okay.
I'm here.
Did you, hopefully you were able to hear the deliberations regarding the continuance request or motion? We don't have a motion on the table yet. I just want to make sure that you and your client, I mean, you can go back and listen to each of the commissioners. I think each commissioner sort of articulated some things along a common theme. I believe that the main component is to grant the opportunity for the applicant to develop further information along the lines of each of the commissioners' requests. At least this commissioner would also like the development of a record that if something is, not doable, let's just pick pipelines. I hope that's not the case, but let's pick pipelines. I would like the applicant to be ready to, fully explain why that opportunity does not exist. If you understand that point, I think that I was taking notes. McGowan, and I'm just trying to summarize this for your client, and I assume that's probably what you'd be asking me to do anyway. That the Form 2B needs to be finished up, reassess the information in the 2B. We don't want assumptions around emissions. We want to know what the emissions are going to be. I think there was a request by Commissioner Cross to go reevaluate all the different opportunities that may exist. And again, if you client cannot come to the table with a better opportunity, we need to expressly know why. Is it that, and I'm just making stuff up, but they're an operator that doesn't have a rig dedicated to them all the time. And then I would want to know the information of, well, what is available? I'm also a little concerned that this chicken and egg sort of thing, like we can't commit until we get closer to start date. We're 3 months from their proposed start date. It said second quarter of 2024. That's pretty darn close. So I would like the pencil to be sharpened a little bit on that front so that we do know precisely the best commitments that can happen. I think that is pretty good. Oh, and then Commissioner Messner indicated that CDPHE would like to have an opportunity for a consult. So we would suggest you take that time to speak with Ms. Sorensen as well. Having said all of that, do you have an opportunity to provide me with a hearing date to which I can continue this matter?
Yes, great. Thank you, Chair. And I've consulted with Red Hawk, and we'd like to propose the January 10th hearing date.
Okay.
Thank you. And I really appreciate the guidance on each of these points. I could hear all the deliberations, even though my video was being odd, but I've got those down. I took the notes from what you said. We appreciate this and appreciate the feedback, and we will sharpen the pencils and we will come back to you hopefully on the 10th.
Very good. I move to continue this application to January 10th.
Second.
AG Mercer, you visualized, do you have something to add?
Thank you, Mr. Chair. And perhaps this was obvious to all folks and so went unstated, but just in case that wasn't the case, I just wanted to recommend that in addition to updating the Form 2B based on these sort of reevaluations, that the 2A also should be updated to clearly indicate which of the various technologies are being committed to. I believe that will make the process cleaner than simply having oral commitments at hearing. So that would be my recommendation.
Okay, I will incorporate that into guidance to the operator about what they're going to do between now and January 10th. We have a motion and a second. Is there further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? The matter is continued, Ms. Jost. We look forward to hearing from you on January 10th, and we wish you good luck in the intervening months to work on the application as instructed. If you need further information about what we said we wanted, this will be posted to the YouTube page shortly. So,
Great. Thank you so much, Chair. Thank you, commissioners.
all right. All right, commissioners. We have one other matter today. It's the Bayswater Oil and Gas Development Plan. As is normal the case, let's take 5 minutes and get everybody up and running, and we'll return at 2:15. All right, commissioners, before we move to the next OGDP, I would like to elevate Tessa Sorensen she and I chatted offline about that last matter, and I think it would be helpful to correct the record to bring her in and allow her an opportunity to provide us with some perspective. Elias, are you working on that? Great. Good afternoon, Ms. Sorensen. Good to have you with us. Thanks for reaching out. This job is difficult, as you well know, and before we move to the next docket, I wanted to give you an opportunity to provide your perspective on some of the comments you heard and some of the direction that was made, because it obviously impacts you and your job, and that's unfair to make presumptions on our part. You are recognized.
Thank you, Mr. Chair. So a couple of items from that last docket item, and that's that it was stated that CDPHE was aware of the equipment being used. That is untrue. I actually can't find that in our records anywhere. CDPHE did receive notice of completeness from the ECMC staff. That actually occurred on October 5th of this year. And upon looking at it, because of the isolation of the site and whatnot, CDPHE did decline a consult for that. We were unaware of the equipment there. I don't think that changes necessarily the need for a consult. If ECMC demands one, I think we could certainly accommodate for sure. But I don't think I think everything's been talked about at this point for that. I do, in reviewing the 2B emissions estimates, I would agree that it is actually unreasonable in the numbers that are there and probably needs additional work on it. But I really just wanted to clear up that CDPHE was contacted by ECMC staff. It's possible that Red Hawk actually did reach out to CDPHE upon application of the 2A for this particular OGDP, but that was my predecessor, so that may have slipped through the cracks. So I really can't speak on that for sure.
Great. Thanks for the clarification. If we are, I think the ask now is that a consult occur.
Sure.
Most importantly, and we had continued it to 1:10. That may not be doable on your calendar, and I'm happy to provide additional time to make sure that you have a reasonable ability to undertake that work.
I think provided Red Hawk is knowledgeable on what equipment they plan on using, that can be done. I think that's up to the operator, not so much Hunter.
Okay. I'll make sure Red Hawk gets this information, and I appreciate your reaching out and willingness to hop on the screen and make some corrective edits to the record. Thank you very much.
No problem. Thank you, Mr. Chair.
Ms. Mercer.
Thank you, Mr. Chair. I would just recommend that we clarify on the record that Ms. Sorensen's statements related to the previous docket, since we had closed and moved on from that matter. Just wanted to try to improve the record there.
Okay, in making that statement, have you accomplished your task?
Yes, Mr. Chair, I believe so.
Very good. Oh, okay. We are now going to move to docket 2302-00037. This is a Bayswater Exploration and Production Oil and Gas Development Plan. Is the Opal Coal Bank OGDP. We initially heard this on November 13th, and we asked for some additional information. And we now have with us Bayswater and Bayswater's attorney, Ms. Ryan. All of your witnesses were previously sworn in, and I would just remind them that they remain under oath to provide testimony unless, Mr. Melrose, were you not with us previously? Is that why you raised your hand? You're muted.
Yes, correct. I was not on the previous call.
Can you raise your right hand, state your name, and swear to tell the truth?
James Melrose, I swear to tell the truth.
You are now officially sworn. Okay, with that reminder, the docket is yours, Ms. Ryan. We look forward to hearing from you and your clients.
Thank you, Chair. Good afternoon. My name is Julia Ryan. I'm a shareholder with Braunstein Hyatt Farber Schreck, appearing to you today on behalf of Bayswater Exploration and Production LLC. We're here for your final consideration of Bayswater's Opal Coal Bank OGDP application. As Chair Robbins mentioned, we introduced this project to you on November 13th, and we appreciate the opportunity to appear before you today to provide additional information regarding two topics. The first topic is the unavailability of pipelines capable of transporting crude oil with higher sulfur content. Pipelines are not possible for this project, and we will explain why in detail for the record. The second topic involves high priority habitat and the on-site consultation we had with Colorado Parks and Wildlife at the Commissioner's request. We will explain new timing stipulations we are committing to in light of the consultation. There will be no presentation from the relevant local government today, as Weld County appeared before you last month to discuss its approved WOGLA for this project and its support. Instead, we'll be focusing on the two topics you asked us to address. Lauren Walsh will introduce the rest of the team and walk you through today's presentation.
Thank you, Julia. So today, in addition to Julia Ryan from Braunstein Hyatt Farber and Schreck, I will be presenting our OGDP continuance. My name is Lauren Walsh, and I'm a landman and senior regulatory specialist here at Bayswater. We also have a number of subject matter experts joining us today to answer any specific questions that may come up. Today, we have Steve Struna, President and CEO of Bayswater, James Melrose, VP of Operations, Tyler Hammond, District Landman, Robert Carney, Completions Manager, Jeff Overman, Drilling Manager, Ryan Kaminke, Facilities and Production Manager, Brad Rogers, EHS Manager, and finally, Ann Feldman is joining us as a regulatory consultant from Ascent. So last month at the Opal Coal Bank OGDP hearing, commissioners requested that the hearing be continued and that we come back to discuss two specific topics. So after I take you back through a high-level summary of the proposed location, I will discuss those two matters, being why pipelines aren't available for this location, as well as high-priority habitat. I will also review the additional items that Bayswater commits to in light of our CPW consultation and further engagement with our electrical provider. Julia will wrap up with a requested relief summary. As you may recall, the Opal Coal Bank OGDP does not trigger any ALA criteria. Most notably, there are 0 RBUs within 2,000 feet. And in fact, there are very few residences in the area outside of 2,000 feet, and there are no large communities or subdivisions. The OGDP received no comments during public comment period, and there were no protests. Bayswater uses first-class comprehensive BMPs, including, among others, Type 3 drilling mud used during drilling operations, a quiet frac fleet utilized during completions, and Tier 4 engines to be used during completions operations. And finally, I would like to stress that the ECMC director did recommend this application for approval. Here you can see the proposed OGDP map. This includes our 2 DSUs, which are each approximately 1,280 acres, and the OGDP boundary, which covers both DSUs. We plan to develop this entire area from a single location with 24 wells. This will minimize our surface disturbance. Additionally, each of the proposed wells has a lateral length of 2 miles. As mentioned before, Bayswater is pleased to be able to present a location that does not meet any ALA criteria, and it was also given the director's recommendation for approval. This slide shows an aerial image of the proposed pad, where you can see that the location is in an extremely rural part of Weld County, There are 0 RBUs, school facilities, or childcare centers within 2,000 feet of the working pad surface. And the working pad surface can be seen here in bright green with 500, 1,000, and 2,000 foot buffers around it in orange, green, and blue. Additionally, for your reference, the footprint just north of the location outlined in black is an electrical substation. Finally, we also use the new CDPHE EnviroScreen score to determine that the location has a low EnviroScreen score falling under the 50th percentile. The first topic that the commissioners asked us to provide additional information on is why this application does not have crude oil pipeline takeaway. As a bit of background, I want to emphasize that even though pipelines are not required by our rules, Bayswater always explores pipeline takeaway for new locations. And when it is reasonable to connect to oil pipeline, Bayswater does so, even when not required by our permits. For example, 2 units drilled southeast of this location, the Riemann and Sapphire pad, with 30 producing wells, were voluntarily connected to oil pipeline this year, although not required by our permit, because Bayswater found it reasonable and possible to do so. Pipeline could be utilized at those pads because the sulfur content of the oil was lower than what will be produced at Opal Coal Bank. Bayswater explored pipeline takeaway for this OGDP, but is unable to utilize pipelines because the oil produced from these units will not meet pipeline specifications. More specifically, the pipeline in the area will not accommodate the sulfur content that we are anticipating from this specific location. Putting oil with a higher sulfur content into the pipeline presents problems for the gatherer and producer and can lead to shut-ins as well as malfunctions. There are no pipelines in the area that can accommodate the sulfur content that we are anticipating at this pad. A public commenter in another OGDP suggested that pipelines were available in the area. However, those projects are miles away and produce oil that has significantly lower sulfur content than the Opal Coal Bank will. In fact, gathering specifications for midstream in this area explicitly state that the oil purchasers have a right to reject oil that doesn't meet their specifications. And in this scenario, the gatherer does not have any obligation to gather any oil with a sulfur content over 0.15%, which we know these wells will have. It is important to recognize that unlike reed vapor pressure of the crude, which Bayswater could reduce with additional pressure reductions and stabilization, the process to remove small amounts of organic sulfur is complicated and requires advanced methods reserved for oil refineries. In other words, there are no additional measures that Bayswater could take that would allow our oil to meet these pipeline specifications. Although we are not able to connect a pipeline and we must use trucks, the emissions are much less than you might think. First, the number of trips drops off sharply over the first 3 years, as you can see on this graph. The number of required trips quickly dwindles because of the production decline from these wells. Note that the trips are shown over only a matter of months, so that by the end of the first year, there are only approximately 23 trips per day. Second, the oil is trucked to terminals that are nearby, with an average distance being 40.1 miles. At the last hearing, we thought that perhaps the oil was being trucked as far as Suncor, but this is not the case, and the endpoints are much closer. With the number of trips being few and the distance traveled short, the NOx emissions due to trucks is only 2.5 tons per year for the first year, which is the year that has the highest production. Similar to the trips dropping off, the amount of NOx from truck emissions will also quickly drop off if production decline. Additionally, since our last hearing, we are reducing emissions in other ways. Specifically, our electrical provider has made substantial progress in its infrastructure build out since our last hearing and is now able to provide us with electricity we've requested to electrify our production facilities. This will eliminate approximately 11.8 tons per year of NOx and 16.5 tons per year of volatile organic compounds, as shown in this slide. Just to provide a bit more detail, this map depicts the Opal Coal Bank location in the northwest corner and the 4 oil terminals that the oil could be trucked to. It is up to the third-party company where they choose to truck the oil to, and Bayswater has no control over the terminal chosen. This could change over time. The second topic that the commissioners asked us to provide additional information on is high-priority habitat. Per the request of commissioners, Bayswater and CPW met on location for a formal consultation just 3 days after our original hearing date. Tyler Hammond, Julia Ryan, and myself met with Brandon Moret, Lexi Hamus-Miller, and Troy Flarian from CPW. CPW asked thoughtful questions at the consultation regarding the location of the pad and the access road. After reviewing and discussing the location, Bayswater was pleased to have received CPW's concurrence that the pad is in the best location for the project. Bayswater commits that it will not drill in the second half of winter, being February 14th to April 30th. And we will not complete during the entirety of the winter months, being December 1st to April 30th. CPW is aware of the commitments and communicated to the site that the site visit confirmed for CPW that the timing stipulations were, quote, appropriate, and that CPW confirmed in writing to the hearing officer Thomas that it was, quote, that it has, quote, no further comments from this location. Our cumulative impact plan and wildlife protection plan have been updated and resubmitted to staff to address the formal consultation and timing stipulations. Given our voluntary timing stipulations for drilling and completions, Bayswater spent a great deal of time to rework our operational timeline. We now plan to begin drilling earlier than originally planned in August of 2024 in order to avoid the most impactful parts of the winter months. And we plan to commence completions operations after winter in May of 2025. This will lead to the 24 wells being produced in November of 2025. We hope that we have clarified the details regarding the impossibility of oil takeaway. And this slide summarizes the changes to the OGDP since our last hearing. In addition to agreeing to CPW's suggested voluntary timing stipulations, Poudre Valley has progressed in their design and load verification, allowing us to commit to 100% electrification of the Opal Coal Bank production facility, which slashes our NOx emissions for this site. Thank you all, and now I'll hand it back over to Ms. Ryan.
Thank you, Ms. Walsh. Commissioners, the administrative record in this case, including what we presented to you today and what we presented to you last month, as well as the director's recommendation, demonstrates that the Opal Coal Bank OGDP meets or exceeds your rules and the Oil and Gas Conservation Act. Bayswater worked hard to obtain pipeline takeaway, but unfortunately, pipelines are just not possible for this location. CPW is aware of our timing stipulations and has no further comments. Potential adverse impacts are avoided, minimized, and mitigated by several aspects of this OGDP, including that the proposed location is in a rural area with no residents within 2,000 feet, and that Bayswater is electrifying all production equipment and using Group 3 mud. Bayswater requests that the ECMC enter an order approving the requested relief in Bayswater's amended application. We really appreciate your time and consideration this afternoon, and the team is available to answer any questions you may have. Thank you.
Thank you, Ms. Walsh. Thank you, Ms. Ryan. We appreciate the additional information that Bayswater has brought to the table for our consideration of this OGDP. Ms. Walsh, just a couple of short questions. And just why is it that Bayswater has no control over where the trucks go to deliver the oil?
Sure, thank you for the question. So it just has to do with the custody transfer point. So we sell the oil when it leaves our pad, and at that point, it's in the control of the gatherer that then takes it to those terminals. So it's up to them at that point, it's their crude oil, and they can take it where they wish.
Does Bayswater have an opportunity to provide perspective from the commission that in its order, if we were to get to an approval here, that we really wanted them to try to take it to the least miles area away? I mean,
I don't think that we have control over that. We were able to confirm those 4 locations that I showed on the map, just from looking at past tickets that show where each load was specifically taken. But I believe it's out of our hands. Steve or James, please correct me if that's incorrect.
Mr. Melrose?
Yeah, so as Lauren states, the oil as it leaves the lease belongs to the purchaser, no longer to Bayswater. And oil is delivered to various terminals for a number of reasons. You know, the trucking company that gathers it for us may sell it to different parties that have availability to take crude at one terminal, but not another. There may be capacity at one terminal, but not another. Or certain terminals connect to certain pipelines that they may then resell that crude to get it out of the basin. So we can't specify to a purchaser that they may only take it to a certain terminal because that'll limit their ability to then move that barrel.
Okay. No, I appreciate the explanation. The explanation was not self-evident from the original testimony, but now it is much more understandable. Ms. Walsh, one additional slight question, and I really appreciated the explanation about the sulfur content and not being able to place that within pipelines because they just won't let you take it. You said twice expected sulfur content, and then the third time you talked about it, you said it's gonna be sulfur that's gonna be too high. Which is it?
I mean, it's expected because we have drilled wells right below these 2 units. So we have evidence that shows as you go further north, the sulfur content increases. So all of our data shows that it will be higher than 0.15 significantly.
And obviously you don't know because you haven't drilled the wells.
Correct, but I think James could speak to it, is that we have a number of data points, and just as you go north, it continues to get higher and higher.
Yeah, that's fine. I'll take your word on it. I just wanted to clarify that point of the record.
Yes, sir. Thank you for the question.
Those were the clarifying questions that I had. Looking around to my fellow commissioners for additional questions for the panel. Commissioner Messner.
Thank you, Mr. Chair. Appreciate the update. I wonder if you could talk, a little bit about the sulfur. I'm understanding that area is known for having hydrogen sulfides. And are we talking H2S in the area? Are you concerned about H2S in this particular area? Or are we talking just sulfur?
I think James or Ryan would probably be the best ones to give you a technical explanation of that.
Yeah, I'd be happy to explain. We are not expecting H2S. The sulfur in the oil is just elemental sulfur. It doesn't come along with associated H2S. We do not have an H2S production stream in this field.
Okay. That was my question. It was a little unclear to me. I was hearing that there was potentially H2S in that area. So,
other commissioners with questions for the panel? All right. Well, I'm not seeing further questions from commissioners for the panel. In looking at this holistically, I appreciated the overview and the benefits, the attributes of this OGDP as articulated by Ms. Walsh, the no ALA, no RBUs, no communities or subdivisions, no public concerns, first-class BMPs, Tier 3 mud, quiet frac-free, Tier 4. The director had a recommended approval that it's next to an electric substation, that it's in rural Weld County. Weld County approved it. The Enviro score was low, as well as the explanation as to why trucks are needed for this to take place, and the agreement with the wildlife CPW and the timing steps. For all of those reasons, I find this project to be approvable. Those are my initial deliberative thoughts. Others with deliberative thoughts? Commissioner Ackerman.
Thank you, Mr. Chair. I agree with you and appreciate your summary of the other issues that we looked at during the last hearing as well. I just wanted to thank the operator for taking the time to provide a more substantive discussion of the issue of high sulfur crude in the existing pipeline infrastructure. I understand that that was additional time and effort by the operator, and I'm very appreciative of their efforts. As the chair pointed out during the hearing immediately preceding this one, significant discussions over actions taken and justification as to why best practices cannot be implemented, especially in the ozone non-attainment area, are really very helpful in our final decision-making process. So thank you for your clarifications. I also wanted to say thank you for taking other actions at other facilities to connect the pipelines when and where feasible, and appreciate you pointing that out today. So, you know, as you pointed out, part of the commission's specific request was to come back and provide that substantive analysis. I appreciate you doing so. I believe that you did, and appreciate your efforts on that front. With regard to the wildlife consultation, I also wanted to thank you for further discussing the issue with CPW. I wanted to state that it's very important to me that we maintain the integrity of the timing of the annual adoption of HPH outside of the context of this hearing and within the notes of this hearing, in order to ensure that the best real-time information is available to each operator during each OGDP, you know, but it's equally important to me that we acknowledge and respect the HPH that is in effect at the time of each application. And so for that reason, I recognize that this is Bayswater's voluntary commitment at the request of the commission to work with CPW on timing limitations, and really appreciate you doing so to the best of your ability under the conditions surrounding the application timeline to partially avoid drilling impacts and to fully avoid completions impacts to HPH during what is really the most sensitive time of late winter. So I am in support of this application, and thank your additional efforts.
Thank you, Commissioner Ackerman. Other commissioners with deliberative thoughts? Commissioner Messner.
Thank you, Mr. Chair. And again, I do appreciate the applicant coming back and providing additional information. I'll start with the rationale for having to truck the oil in this particular situation. And I think that the level of detail that was provided today was certainly helpful. And I think that that rationale, you know, is reasonable. I mean, I think oil takeaway is really, really important. But I think that it's reasonable in your conclusion on why it's not possible in this particular area. And I think it's uniquely reasonable. I don't think that this is a very common thing that should be happening in these areas. But I do, this one makes sense to me, so I do understand that. As to the wildlife consultation, I appreciate that there was a consultation that occurred, and that timing stipulations were agreed to as part of that consultation with CPW. I have a little different take, I think, you know, on that. I think while I appreciate that Bayswater did agree to those, you know, at least from my opinion, Rule 307B1, as well as, you know, a number of other rules, you know, regarding those high priority habitat maps, clearly line out when it is appropriate for additional consultation to occur to ensure protection of wildlife. And I think that's what occurred here, was a request for additional consultation by the commission in order to ensure protection. in an area that potentially had wildlife implications to it. And so I do appreciate that that consultation did occur, and that you agreed to have the timing stipulations in place in order to ensure protection of wildlife in that in this particular application. And so I too think that this is approvable after the updates that were provided today. I do want to make a comment that while I appreciate you continuing to bring up the director's approval in consultation or in presentations on applications, this is an independent review body that looks at things independently to ensure that the rules are applied and that it passes the approval of this particular body as an independent review body. Oftentimes, I don't feel like the director's recommendation has enough specificity in its findings to actually provide necessary information for me to do the review. And so I'm looking at this application independent of the director's recommendation based on the application that's presented here. And so I think I just wanted to share that as information on how I'm reviewing it. And so while I appreciate that the director approved this one, I'm looking at it differently and independently. And so anyway, those are my deliberative comments, and I do believe that it's approvable with the additional information provided today.
Commissioner Cross, Commissioner McGowan, anything to add? Commissioner Cross?
Thank you, Mr. Chair. I just want to say thank you for coming back with the additional information. I agree this is an approvable plan. I appreciate the time that was spent on it, and the steps that you've taken, not just in coming back, but with the BMPs that were proposed from the beginning and now, and the clarifications made. So thank you.
Very good. AAG Mercer, if you could daylight yourself. Hello. I want to make a motion to approve, but I didn't know if I needed to add in anything else or if we're good to go.
Yes, Mr. Chair, I believe it would be appropriate for your motion to include the 2 BMPs proposed in the applicant's presentation. Those were 1, to electrify all production equipment on the facility. Right now, the BMP excludes some of that equipment, so that would need to be swapped out. And the second is the commitment to the timing stipulations as detailed in their slides.
So moved. Commissioner McGowan?
Thank you, Mr. Chair. So AAG Mercer, would it be appropriate for us to also ask for an updated 2B now that they're electrifying their pad?
Yes, Commissioner McGowan, I think that would be appropriate.
I second the motion if the motioner sees a friendly amendment to also update the Form 2B.
Friendly amendment approved. We have a motion and a second. One deliberative or one comment, since Commissioner Messner provided his comment about the director's recommendation, I think you should hear from other commissioners about that. I appreciate the fact that we have a director's recommendation. I appreciate Commissioner Messner that we are an independent review body, but I do provide substantial, I find a substantial assist when I've got a director's recommendation for approval. And so I want this applicant, the world, to know that perhaps Commissioner Messner and I look at it a little bit differently, but you ought to know from each commissioner how we do our jobs here. So from my perspective, the pointing out the director's recommendation and whether it's, substantial, good, or otherwise is helpful, because I do rely on it. So has nothing to do really with my vote here. I just want you guys need to understand how all 5 of us work, and that we all 5 work independently and work things a little bit differently. So that's my perspective on that front. Anything further from commissioners before we take a vote? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Seeing none, the motion carries. Thank you very much to the panel. Appreciate the work here and glad that we have gotten to a space where we were able to approve the OGDP.
Thank you.
All right,
Well,
commissioners, that concludes the business for today, but it doesn't conclude the business for this week. We're coming back tomorrow morning. We've got 2 OGDPs scheduled to commence at 9 a.m. I guess I'm just looking for a motion to continue this matter to 9 a.m. on December 14th.
Moved.
Second.
Motion and a second. All those in favor signify by saying aye. Aye. Any opposed? Motion carries. See you in the morning.